Good evening and welcome everyone. I'm calling the December 2nd City Council meeting to order. I'd like to ask those who'd like to join the council, myself, in the Pledge of Allegiance to please stand. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Our first item this evening is under special business, ID 0599. It's a swearing-in ceremony and oath of office for our new council member in position 3, Barb D. Michelle. In February 2018, the council appointed Ms. Hunt to fill position number 3 until the next scheduled municipal general election. On November 26, 2019, the results of the election were certified and Barb D. Michelle was elected to serve Issaquah in position number 3. Ms. D. Michelle will now serve the remaining 2-year term of position number 3, expiring December 2021. Barb, would you like to come and join me over at the lectern? It's time for cameras. If you've come for Barb, get your cameras out. Barb, can you raise your right hand and repeat after me? I state your name.
I, Barbara D. Michelle,
Having been duly elected
to
City of Issaquah, Council Position Number 3,
to City of Issaquah, Council Position Number 3,
term expiring December 31st, 2021,
term expiring December 31st, 2021,
do solemnly swear
that
I will faithfully and impartially discharge the duties of this office as prescribed by law, and to the best of my ability, that I will support and maintain the Constitution of the State of Washington
the Constitution of the State of Washington
and of the United States of America.
and of the United States of America.
Congratulations. Let's get a picture with you.
Okay.
Thank you, Tisha. I didn't see a lot of flashes, so I figured we had to do some extra pictures. Thank you, Tisha.
This is my photographer.
Oh, there you go.
She brings an entourage.
Thank you. Congratulations.
All right. May I introduce my family real quickly?
I think that's fine.
Okay.
Come on over and
I'll just be really brief. I'd like to introduce my son, John, my daughter-in-law, Diane, my granddaughter, Iko, and my grandson, Robbie, and many supporters in the audience. Thank you so much for being here.
thank you all for coming.
Yes.
So at this point in time, I'm going to call, I know we just started, a very short recess because we did have some folks that came tonight for the swearing-in ceremony and not for the rest of our regular business. So we will be in recess for 5 minutes, coming back at about 7:09.
You can say, is anybody leaving? Hello to all of your.
Yes.
You may talk. So we are back on air, and thank you for your patience. We wanted to make sure that Barb's family was able to stay for as long or as little as they wanted to stay tonight, and that opened up a few seats for us in the front. So I'm calling the meeting back to order, and the next item on the agenda is audience comments. There are a lot of different things going on tonight and different proceedings, and so I have quite a lengthy introduction to audience comments tonight. This is the time for audience members to address the council, and the guidelines for public participation are displayed on the screen behind us. Due to the anticipated length of tonight's meeting, and in accordance with section 4.08(c) of the council rules of procedure, I will be limiting audience comments to 3 minutes each, with an overall duration for this evening of 15 minutes. Those who signed up will be called forward first. If you did not sign up and there is time remaining, I will ask for other speakers before closing this portion of the meeting. If you are here as part of a group, please identify yourself as a spokesperson in the group that you're here for. And if you are here this evening listening and you hear comments and you want to indicate to the council your support of what you're hearing, please raise your hand so the council has an idea of your support. I'm going to talk a little bit about a quasi-judicial hearing that is happening this evening. So as many of you know, the Providence Point Umbrella Association has filed an appeal of the SEPA determination of non-significance issued by city staff for the comprehensive plan redesignation and rezone request related to the Issaquah School District property. The appeal hearing will occur later on the agenda during tonight's council meeting. This appeal is a quasi-judicial decision. When something is quasi-judicial, that means the council must act like judges and may not hear any testimony or evidence related to the appeal outside of tonight's appeal hearing. This means the city council may not hear audience comments tonight on any of the issues in the SEPA appeal. This is clarified in section 4.0(a)(b) of the council rules of procedure. For those not familiar with the issues in the SEPA appeal, in summary, they are whether the school district should have been the applicant for the comprehensive plan amendment and rezone rather than the city, whether the information on the SEPA checklist used to evaluate the potential impacts of the 2019 comprehensive plan amendment and rezone package was adequate and complete with respect to the school district property, whether the city appropriately used phased environmental review in this instance, whether the not applicable answers to some of the questions on the SEPA checklist are accurate, and whether the comprehensive plan amendment and rezone of the school district property will have probable significant adverse environmental impacts. Once again, the council cannot hear testimony on these issues under audience comments tonight. If you speak on any of the SEPA-related issues, I will have to stop you and will ask that you refrain from speaking further on these matters. You are welcome to speak on other issues. So with that done, I'll turn to our clerk and ask if anyone has signed up to speak this evening.
Yes, William Freisinger.
On up, Bill.
And we have a new podium or lectern for you.
Sorry, Bill. We
Thank you.
rearranged the furniture. There you go.
Yes, I want to address the traffic issues in Old Town. I'm Bill Freisinger. I live at 415 Southeast Bush Street. So I'm in that middle of that area. I'm a couple blocks from the intersection of Bush and 2nd, which is a particular concern area. And I want to thank the city staff for work they've done already. They've added extra traffic control on 2nd Avenue near Bush. And I noticed they were monitoring traffic flows. I'm sure you'll get a report on that. Anyway, my particular concern is that you not get carried away and eliminate the left turns into the neighborhood. My experience in the neighborhood is that the people were very upset when the no left turn signs went in and very relieved when they went out. If these initial things that have been done to mitigate the traffic has not been adequate, we could consider perhaps like on intersection of Andrews and 5th, there's a little traffic island. A traffic island could also be put on 4th and Bush. While the teenagers might enjoy flying over the bumps, they won't enjoy one side of their car going over the bump when they speed through the traffic island. I mean, if you put the no left turn signs into the neighborhood, it will cut down on going through traffic. You could also close off those streets, 5th and 6th at sunset. That'll help even more. But those are both bad ideas and should only be viewed as last resort. Thank you very much for your time.
Thank you, Bill. Has anyone else signed up this evening, Tisha?
Yes, Jenny Bingham.
Jenny, come on up.
Jenny Bingham, 375 Southeast Andrews Street. I'm also here to talk about the Old Town traffic calming. In looking at City of Seattle Municipal Code 11.14.300, they have a local access traffic only. And that means motor vehicles having an origin or destination along a non-arterial street within an area bounded by arterial streets, except where boundaries are otherwise set by officials, erected traffic control signs or topographical. And the violation of the code for that is like $124 or $191 if there is a collision. The RCW on that is 46.61.050. No person shall disobey the applicable instructions of the unofficial traffic control device unless directed by a peace officer. That's what it says, police officer. My recommendation for the Old Town traffic calming, which I've been here for 20 years regarding this, ever since the Highlands was built, caused more traffic and more building out of our city, is number one would be completely close off 6th Avenue at Sunset Way, no in, no out. Completely close off 4th Avenue at Sunset Way, no in, no out. Make 5th Avenue the only access in and out with signage that says local access traffic only. Signs would be posted on Sunset Way before 5th Avenue, and it would say local access traffic only. We would still get, we would ask also that they be posted on 2nd Avenue at 5th and Bush, or excuse me, at 2nd and Bush and 2nd and Andrews. 5th Avenue from Sunset Way has a sidewalk, but would need a crosswalk running east and west at entrance off 5th of Sunset Way, again east and west on Andrews and Bush as well. To slow any traffic, another speed hump to be added between Sunset Way and Andrews, running east and west. The traffic circle is already there. I would suggest adding some more curbing so people can't just dash around it. That will manage the vehicles. And there should be another speed hump between Andrews and Bush, running east and west, with a crosswalk as well there. As we all know, we need crosswalks to keep from another thing happening that happened on 6th. Local access traffic only, signs installed on 2nd Avenue, Bush, and Andrews.
Excuse me, your comment period has ended.
Okay,
Jenny, do you want
Thank
to,
you.
if you have some quick comments just to wrap it up, that'd be good.
thank you very much.
Thank you, Jenny.
We want some feedback. We want to know a little more about the strips that were put down. We want communication, and we want to know as soon as possible what the counts were. Thank you.
Thank you. Has anybody else signed up this evening?
Yes, Dwayne Stranard.
Yep. Dwayne Stannard, 420 Southeast Bush Street, 5th generation Issaquah. I agree with Jenny and what she was talking about. Also, too, I would like to add, if you're heading east on 2nd or on Bush Street, on the intersection of Bush Street and 2nd Avenue, no left turn. This is an intersection I use quite often, and it really gets interesting when people are trying to make a left turn. They come down off the hill from the high school, they get confused because of the crosswalk, and it can be a disaster at some point in time. So, you know, and then don't take away our left turn into our area. when we had the no left turns, it was an added 20, 25 minutes, depending on the time of day, to go down the Second, go down the Second, turn left, go up Andrews on the 5th, and then back down to my house on Bush Street. And that's about all I have to say. Thank you very much.
Thank you. Has anyone else signed up this evening?
No, and we have approximately 6 minutes remaining of the 15-minute comment period.
Right. So if there's anyone else in the audience tonight that wants to make comments to council not related to the hearing that's happening later this evening, come on up to the podium. We have 6 minutes left. And if I don't see any hands, I'll ask a second time. Would anybody like to come up and speak to council this evening? And a third and final time. Seeing none, we'll close audience comments. And we will move on to committee and regional reports, starting with Councilmember DiMichele. I'm laughing because she hasn't been to a committee meeting yet, so.
No report.
Thank you. Councilmember Walsh.
Thank you. I have no report at this time.
Thanks. Councilmember Ray.
No report.
Councilmember Winterstein.
This Thursday is a meeting of the Puget Sound Regional Council's Growth Management Policy Board, meeting in December, which we don't usually do, but there is optimism that the board will get through all proposed amendments and we'll be able to make a recommendation to the executive board before the end of the year. We shall see. That concludes my report.
Thank you. Councilmember Goodman.
Thank you. The Eastside Fire and Rescue Board of Directors will meet on December 12th at 4 p.m. at the headquarters building on Newport Way, and I do not have an agenda yet.
Thank
That's
you.
my report.
Thank you. Deputy Council President Batiste.
Thank you, Madam Mayor. The Puget Sound Economic Development District Board will be meeting on Wednesday, December 4th from 1 to 3 in Seattle. And on the agenda will be some housekeeping items, the 2020 board focus areas, the regional aviation baseline study update, and an overview of the Amazing Place implementation thus far. And that concludes my report.
Thank you. Council President Martz.
Thank you, Madam Mayor. Next Wednesday, December 11th, will be the SCA, Sun Cities Association Public Issues Committee meeting. At the 6 p.m. pre-pick workshop will actually be 2020 Board of Directors elections. There are actually in the North Caucus, all 4 seats are up for election. All 4 seats are vacant because well, several members of the SCA board were not returned to office this fall. So then the meeting, the regular meeting at 7 p.m. will be election of 2020 pick chair and vice chair, regional board and committee appointments, which will come out of the nominating committee, I think about 48 hours before that meeting. We're going to probably adopt the 2020 SCA legislative agenda. There will be an update on the regional homelessness response. I don't see a specific action being in the draft agenda. I had hoped this evening to have a conversation about the regional homelessness response, but owing to the very full agenda for this evening, we are not going to try to have that conversation. Keep apprised of what's going on with PIC, and I will try to send out an email ahead of next week's meeting summarizing where things are at and asking for individual feedback from you. Then also discussion of 2020 SCA priorities, which is things that we want to talk about in the upcoming year. That concludes my report.
Thank you, Council President Martz. The mayor's report is very brief this evening. An executive session is not anticipated to occur. We have a lot of work to do this evening, so I also did not want to have a very long report. We're going to move to the consent calendar. The consent calendar was distributed to council in advance, and if authorized, the items on the consent calendar will be considered together and approved by one motion. Have the payables and payroll been reviewed?
Yes.
Thank you. Does any council member desire to remove any item from the consent calendar and consider it under regular business? Seeing none, is there a motion?
Madam Mayor, I move we adopt the consent agenda as listed in this evening's, the consent, this is why I
Calendar.
write these things down normally. The consent calendar as listed in this evening's agenda.
Thank you. Is there a second?
Second.
It's been moved and seconded. All those in favor signify by saying aye.
Aye.
Those opposed? That carries unanimously. Under regular business this evening, our first item is AB 7854, amending the Issaquah Municipal Code 13.24, 13.3, and 13.70 utility general facilities charges, and it is a request for council to adopt the ordinance. This item was heard by council at the October 22nd study session, and I'd like to ask Bob York, our engineering manager, to the lectern.
Good evening, Mayor and council members. I'm Bob York. I'm Utility Engineering Manager in Public Works. Just a second.
We have different information up on the screen.
I have a brief presentation tonight on agenda bill.
Bob, I'm going to stop you for a second so we can make sure on our screen here.
Oops, I have the wrong one up. Hold on.
Oh, got it. Okay. Thanks.
Go to, yeah. The other one is. This one.
Great, thank you.
I have another presentation coming up, but this is the first one. Agenda Bill 7854, General Facility Charge Adjustments for the Utilities. First, a quick definition of general facility charges as a refresher. Those are one-time charges paid when a new or expanded service is requested from an applicant or developer. The GFC is calculated using a strict methodology specified by State of Washington regulations and is intended to bring equity between existing customers and new customers connecting to the city's utility systems. In other words, it follows the principle of growth pays for growth. Here's a chart showing the overview of tonight's proposed changes. As you might recall, the GFC for water is not going to change because the council at a previous meeting said pull the water treatment plant, so the result is no change to the water GFC. We do propose changes as outlined in the GFC report that's attached to your agenda for sewer and stormwater. And I'll go through each of these briefly in the subsequent slides. We also, as proposed in the GFC report, would like to add a automatic inflation adjustment each year so that the GFC is increased based on a certain index that reflects the construction cost changes in the Seattle area. And finally, for the water, and that would apply to all three utilities. Finally, for the water general facility charge and the Cascade Water Alliance RCFC regional capital facility charge, we would like to clarify the code to be in coordination with recent changes to the Cascade Water Alliance policies. This is up on the screen is the proposed changes to the GFCs for sewer and stormwater utilities. The sewer would go up by $100 from what it is now, and the stormwater would go up by $201. No change to the water, so the total increase for a typical single-family residence would be $301. The GFC annual inflation adjustment, inflation index adjustment would be an automatic adjustment starting not in January 2020, but January 2021. It would be an automatic adjustment based on the annual percent change in the Seattle Area Engineering News Record Construction Cost Index. This is, as recommended in our report, it's commonly used in other jurisdictions. The GFC would actually still be reviewed every 5 years because we want a true up based on the past and forecasted growth projections, the recently completed projects, and the upcoming CIP. So the general facility charge true up would occur because of that need to make sure we're still balanced. But we feel like, staff feels like an inflation adjusted GFC would be more representative of the changes that occur over the course of time. Two clarifications in our code for the water and general facility charge and the CWA regional capital facility charge. One is the basis for payment for a new water meter is based on the domestic size. We do not charge an increase for a larger size meter due to the many facilities have fire suppression systems. That extra meter charge is not included in the GFC calculation. That's the current policy. The only change we would make to be coordinated with Cascade Water Alliance's recently adopted resolution is to, if there's a lack of documentation associated with the difference between the domestic and the actual meter size, we would default to a calculation that's 1 meter size smaller than the one proposed. The vast majority of people, if not all, provide those calculations, so essentially it wouldn't make any change in the normal situation. And the other thing we'd like to do for both the RCFC and the GFC is to document in our code that if you don't have evidence of having a past payment for a general facility charge or the RCFC, we would not give you credit if you're coming in for a new or increased meter size, which is our policy, but now we're making it clearer in the code itself. So our recommendation is proceed with the proposed changes as shown in the agenda bill. Any questions?
Questions? Councilmember Ray.
So I'm a little confused. So the recommendation from the administration is to adopt 3 ordinances to approve changes to the IMC. That includes water, stormwater, and sewer rates?
Correct. And actually 3 ordinances, because that's our best way of making sure that we have a single ordinance for each policy decision.
Okay, so the water, but we're not changing the water GFCs.
That's correct.
And so the purpose of the ordinance is really to adopt the inflation
Index for future scenarios.
Okay, great. Thank you.
Thank you, Councilmember Ray. Councilmember Goodman?
I just have a question about the HDR report, and that it's a draft report, and I was wondering why we have a draft report.
It's a final report. We, in our haste to put this into the agenda, we took what they had and it's essentially a final report. I should have taken the word draft off.
Okay, thanks.
So
Thank you.
it won't change as a result of tonight's deliberations.
Additional questions? Council President Mertz.
Thank you, Madam Mayor. I move to adopt ordinance number
2889.
amending section 13.24.090 of the Issaquah Municipal Code relating to water rates and charges. Adopt ordinance number
2890.
amending section 13.30.055 of the Issaquah Municipal Code relating to stormwater rates and charges. And adopt ordinance number
2891.
amending section 13.70.020 of the Issaquah Municipal Code relating sewer rates and charges.
Second?
It's been moved and seconded. Is there any council discussion? Seeing none, I'll call for the vote. All those in favor of the motion signify by saying aye.
Aye.
Those opposed? That carries unanimously. The next item on the agenda on regular business this evening is AB 7861. This is an interlocal agreement with Eastside Fire and Rescue, the PFAS study partnership. And the request of council is authorization. This is the first time this agreement is coming before City Council. And again, Bob Bjork, Engineering Manager, is going to do a small presentation.
Run through. How many guys? I gotta go back and Okay, council members and mayor, Bob York again, Public Works Engineering Manager for Utilities. Tonight I'm going to give you an update on the Issaquah Valley PFAS Partnership. PFAS, for reference purposes, stands for per and polyfluoroalkyl substances. Tonight's presentation involves two agenda bills that are both on your agenda tonight. One is AB 7842. The other is 7861. 7861 is an interlocal agreement with Eastside Fire and Rescue, PFAS Study Partnership. AB 7842 is interagency agreement with the Department of Ecology, PFAS groundwater modeling. Both these agenda bills are part of the partnership, and I'll go into the details shortly. Here's a timeline, a brief timeline of the occurrence of PFAS in Issaquah coming up to today's decision. In 2015, we confirmed that there was PFAS in the groundwater. In 2016, a number of initial actions took place, as many of you might recall, including a water treatment plant at Well 4 and studies, hydrogeologic investigations regarding the nature and extent of PFAS in the groundwater. All these were directly performed by the city in the absence of a partnership. Following that work, in 2017, 2018, there was a evolution. Eastside Fire and Rescue got involved. The Department of Ecology got involved because we're one of the initial recipients of a PFAS groundwater problem for our municipality. So we're sort of a pioneer. As things evolved, there was a interlocal agreement in August of last year that the council approved between Ecology, Eastside Fire and Rescue, EFR, and the city. There was also $200,000 of grant funding from the state, the Department of Commerce, that we spent on consulting investigations. And we completed the phase 1 report, or Eastside Fire and Rescue did, with the city and Ecology, and in early 2019, the phase 1 report was complete. Now the timeline evolves. We got some additional grants I'll talk about, and in late 2019, today we have the decision to make as to whether to continue the partnership with Ecology and Eastside Fire and Rescue. This slide's in your packet, but it essentially is a repeat of just what I just said. The one additional thing is the partnership would continue by adopting the ILA and the IAA through mid-2021. That's a year and a half from now is the timeline for the next phase of work. Essentially, the partnership agreement principles are, as in the past phase 1 effort, there's an executive committee from the city. It consists of the mayor and the city administrator. From the fire department, it's the fire chief, and there's an ecology representative as well. The legislature this year gave us $400,000 to continue the partnership. This is dedicated to consulting work. Ecology chipped in another $100,000 of money, so the total external funding available is $500,000. The agreement principle is anything over and above that would be split between the city and Eastside Fire and Rescue 50-50. The way the interagency agreements, there's 2 of them, one for Eastside Fire and Rescue and one for the city. The Eastside Fire and Rescue's already adopted a $450,000 interagency agreement, and tonight the city has the opportunity to adopt the interagency agreement supplying the other $50,000. The reason for this is the 50,000 is for hydrogeologic modeling support. The city's consultant's going to do that, and the partners agreed that this would be a prudent way to handle the financial portions of this. The total expected cost of the consulting work between Farallon, the Eastside Fire and Rescue consultant, and Geosyntec, the city's consultant, is $525,000. So that would require both parties to chip in an extra $12,500. In the case of the city, it would come out of our city water fund. The ILA is in Agenda Bill 7861. It's already been approved by EFR at their recent board meeting. Essentially, it defines the next scope of work for the EFR's consultant, defines the executive committee, financial contributions, period of performance, and the and additional technical details. Interagency agreement with Ecology, between the city and Ecology, defines the scope of work for the city's hydrogeologic consultant work, modeling support, defines the period performance reimbursement details. But this is all done in conjunction with the partnership. The city's responsible for this interagency agreement, but it's all supports the partnership between the city, Eastside Fire and Rescue, and Ecology. So the staff's recommendation tonight is to approve both these agenda bills and the interagency agreement and the interlocal agreement. That's my presentation for tonight. Any questions?
Thank you, Bob. So we will consider them as separate motions, but if you have any questions on either agenda bill, please feel free to do that now because they are connected. Any questions of staff? Councilmember Winterstein?
Bob, thank you for that presentation. I'm also going to ask my colleagues who are on EFR later on to maybe hear their version of it as well. Could you just simply, in simple terms, characterize what's going to be accomplished by this work? There is material that's in the bill, and I've read that. It sounds like we're going to learn more. We're going to learn more about in the immediate proximity where we think there are sources. We're going to learn more about what's in the ground potentially upstream from that. And we're maybe going to outline some type of, I forget the right way to describe it, but some remediation, some way to treat the soil or what have you. But it's not a final solution envisioned.
No, it's still leading to a final solution. The Farallon scope of work, the final element of that scope is to develop a source remediation action plan for dealing with what's in the ground and in the groundwater. So that would be encapsulated in a final report that would be available for the partnership.
So it's roughly 2 years from now, we'll maybe have a plan. Is that kind of the time frame?
Essentially my understanding,
Great, thank
yes.
you.
Additional councilmember questions? Councilmember Goodman?
There's no more questions. I was going to make
For
a motion. Yeah. I would move to authorize the mayor to enter into and execute the interlocal agreement with Eastside Fire and Rescue regarding PFAS investigation in the lower Issaquah Valley.
Second.
It's been moved and seconded. Is there any council discussion? Councilmember Goodman, Councilmember Winterstein.
I was just going to say that the questions at the Eastside Fire board meeting really, there were very, very few, and it really was about, the questioning was about whether wearing our board director hats really was about whether the district was comfortable with what was in the agreement. And I think the board was pleased with the good working relationship between Eastside Fire and City of Issaquah and Ecology.
Thank you. Councilmember Winterstein.
That's really the same comment I had. I've obviously been aware of this issue since it first surfaced, and the state of the working relationship between all the parties. It's great to see. This is how we're going to get something done. As you said, maybe in front of maybe other places in the country, but it's necessary work. And I'm thankful to my colleagues here who's on the council who also serve on the board, and for the EFR board and for Ecology as well. I'm glad we're moving forward in such a constructive way.
Thank you. Any other comments? Okay, I will reread this. All those in favor of authorizing the mayor to enter into and execute the interlocal agreement with Eastside Fire and Rescue regarding PFAS investigation in the lower Issaquah Valley signify by saying aye.
Aye.
Those opposed? That carries unanimously. Would you care to make a motion on the next agenda bill?
Yes,
Councilmember Goodman.
I have the right one. This is about ecology, right?
7842.
Yes. I would move to authorize the mayor to enter into and execute the interagency agreement with the Washington State Department of Ecology to conduct groundwater modeling for the lower Issaquah Valley aquifer.
Second.
It's been moved and seconded. Is there any council discussion? Seeing none, I'll call for the vote. All those in favor signify by saying aye.
Aye.
Those opposed? That carries unanimously. Thank you, Bob.
Thank you.
Next item under regular business is AB 7878, Low Income Utility Assistance Program, and the request of council this evening is to adopt the ordinance. At the November 18th council meeting, council directed the administration to draft an ordinance establishing a utility assistance program and to return to tonight's meeting. I'd like to ask our Director of Sustainability, David Fujimoto, to the lectern.
Good evening, council members and Madam Mayor. I'll just make some brief, give you a brief overview of the ordinance that's presented before you. The ordinance would adopt a utility assistance program, which would be an expansion of the utility assistance to include additional residents regardless of age, disability, or housing type. It's important to know that this is an initial program. We're planning to launch this for 2020, but expect to undertake a review as a part of next year's work program to make some adjustments as we go forward. That's also reflected in the ordinance as well. The current program includes low-income owner-occupied single-family seniors. It'll be expanded to include low-income seniors in single-family homes who also rent those units. And then it'll also be expanded significantly to include all low-income households, including renters and owners that live in multifamily homes. It will take the form of a discount for low-income single-family seniors, and then a rebate for the other low-income households. And with that, I'll be happy to answer any questions.
Thank you, David. Are there questions for the director? Councilmember Walsh.
So David, you said this expands to seniors who rent in a single family?
That's correct.
Situation. So my understanding was one of the reasons we were looking at a rebate for just the regular low income was through a multifamily. You can't get to the individual because they don't have their individual utility. So in a situation like that where someone is renting, the utilities are in their name at the residence, and that's why even though they're renting, we can do a percentage of the bill, not just a rebate, right?
We can, yes.
Okay, thank you.
Thank you, Councilmember Walsh. Additional questions? Councilmember Winterstein?
Clarification on the cost. There is a section in here about financial information. It does talk about the cost being expected to be in the range of $108,000 to $216,000 a year. I assume that's is that cost or how are we funding that?
That would be included as part of the overall rate base. So you could also think about it as revenue that the city would not receive from those customers.
That's okay. All right. And that revenue would have gone into the various to which funds?
It would be split among the three different utilities. So stormwater, sewer, and water.
Okay, so if we would have just wordsmithed it a little bit, it would have been a reduction in revenues to those various
Correct.
utility funds in this range.
That's correct.
Okay, thank you.
Any other questions? Councilmember DiMichele.
Well, first of all, I want to thank Director Fujimoto for answering some questions that I sent him as a citizen before I came up here. I asked you if you were going to do outreach to individuals whose language is not English, and you assured me that that is going to happen. And then we talked about the application process, because sometimes the application process for these kinds of rebates or these kinds of assistance are so onerous that they become barriers. And do you want to talk a little bit about the application process and what that would look like for a typical applicant?
Sure, I'd be happy to. Certainly one of our objectives with this is to make the application process as simple as possible, especially from the customer standpoint. We also were taking into consideration the administrative costs from the city standpoint, but first and foremost, really thinking about it from the customer standpoint and trying to simplify that process as much as possible. The linkage to Puget Sound Energy's program helps with that, because they will already have to undergo kind of an income verification process, and so we would not want to repeat that in this case. And so our hope is that the application process for the city can be very simple. We're hoping that it can be one page, that it would provide a linkage back to Puget Sound Energy's program. We'll be meeting with Puget Sound Energy in the next couple of weeks to talk about how we can share that information. We have some details to sort out about how that works. But essentially, a resident would be able to fill out that application. We would be able to verify their participation through communication with Puget Sound Energy, and that would greatly simplify it. Also, if we're able to do that without including personally identifiable information, we may be able to do that electronically and simplify it as well.
That would be great.
Thank you. Any other questions? Council President Martz.
Thank you, Madam Mayor. I move to adopt ordinance number
2892.
establishing a provisional utility assistance program and amending IMC 13.92 senior citizen and low-income citizen fee reductions.
Second. Lots of seconds. I am not surprised. A second. Okay. It's been moved and seconded. Is there any discussion? Council President Martz.
I want to thank city staff for putting together this program so quickly. We had given you the request that we wanted this in place when the rate changes that we authorized for 2020 went into effect, and you did. One can argue where the point should be. I think this is similar, is like-minded to other municipalities on the east side. I think this is a twofer, because not only are we looking out for the most vulnerable in our community, but this will also, I think, encourage, I look at the fact that there are approximately 1,200 families that would be almost certainly eligible for this program, and the current program that's out there that we're piggybacking off of, only 354 families currently take advantage of that. So my hope is that by sweetening the pot, as it were, and by putting our own formidable community resources in place, we can help folks at risk to be educated on these programs and sign up for them. So in that sense, it's a twofer.
Thank you. Deputy Council President Batiste.
So I would just like to echo what Council President Martz just spoke about. I wanted to thank you and the entire team for working so diligently to get this done in such a short amount of time, as we faced looking at utility taxes and everything that we went through with budget. This was incredibly important to me, and I was just really happy to see this in place. And while I won't be here during the review, but I know my fellow council members will take a close look at eligibility and things that might improve the program for the future. But this is version 1, and I'm so happy to see it in place as we go forward, and hoping that we can also really work on the communication so everyone can understand that this is available. Thank you.
Any other comments? Okay. If there's no further discussion, all those in favor of adopting ordinance number 2892, establishing a provisional utility assistance program and amending IMC 13.92, senior citizen and low-income citizen fee reduction, signify by saying aye.
Aye.
Those opposed? It carries unanimously. I also want to thank the council and the administration for being able to accomplish this through a very packed budget session. You talked about this a lot. I am really glad that it's happening on January. Great. The next item on the agenda is the State Environmental Policy Act appeal. Council President Martz will be presiding over this portion of the meeting, and I need to call a 5-minute recess in order for us to allow the parties to move into the correct places. So we will be taking a 5-minute recess until about a little after 5 to 8.
You're addicted.
We are back on camera, and the next item is AB 7877, State Environmental Policy Act Appeal of Comprehensive Plan and Zoning Map Amendments. This is a quasi-judicial proceeding, and I'm going to turn this over to Council President Martz.
Thank you, Madam Mayor. We will be hearing appeal number 19-00006, filed by Providence Point Umbrella Association of the final determination of non-significance for 2019 Comprehensive Plan and Zoning Amendments. The appeal has been filed under IMC 18.10.270, 18.04.250, and 18.04.256, which provides for an open record appeal of a SEPA procedural determination of a non-project action to be heard by City Council. The Council will be issuing a decision in this appeal based on the official record that will be created at this hearing, which will consist of the notice of appeal, the parties' briefing, and the testimony, submission of evidence, and information presented by the parties participating during this hearing. The SEPA appeal hearing is a quasi-judicial proceeding. In this appeal hearing, the Council is serving like a court. We are also subject to the appearance of fairness doctrine. This proceeding must be procedurally fair and conducted by impartial decision makers. First, we will address ex parte communications. Under RCW 42.36.060, no member of the Council may engage in ex parte communications with appellants, city staff, or any third parties with respect to this SEPA appeal without making the appropriate disclosures. Comment letters. The city has received comments on the proposed legislative action underlying the SEPA appeal, specifically the comprehensive plan and zoning map amendments, but it is my understanding that the city clerk's office has not forwarded comment letters to council members that reference or otherwise pertain to this appeal. At this time, I will ask if any members of the council have engaged in ex parte communications concerning this SEPA appeal, and if so, I will ask the council members to disclose the contents of those communications at this time. Councilmember DiMichele.
Okay. It's come to my attention that there's some concern about an email that I sent on September 20th to the city staff. And in that email, I stated my approval of the entire package of rezones for the comprehensive plan amendments. It was prior to October the 26th when the SEPA appeal was filed. It was also prior to the Planning Policy Commission ruling. And at that point, on September 20th, I did not understand or realize that there was any controversy at all about the parcels 1, 2, and 3. My comments were actually directed at parcel 14, which is a small parcel on the corner of Newport Way and Front, about 3 blocks from my condominium, and it is being proposed to be set aside as part of a proposed eventual park. So I was responding to that particular parcel. As soon as it appeared possible that I was going to be elected to this position, I did disclose this email to both the city administrator and city council. And I was advised at that time that my email did not pertain to tonight's hearing on a SEPA appeal, but instead was related to the item that will become before us on December the 16th, which is the rezone. And I just want to state that I feel very confident in my ability to hear the appeal tonight, to remain fair and impartial throughout, and to render a fair and impartial decision.
Thank you. I will state at this point that parties to this appeal will be allowed to rebut the substance of communications disclosed in ex parte communications at the hearing. I will ask if we have, at this point, where we stand in regards to this disclosure of ex parte communications.
Do you want to introduce yourself?
Sure. Is this on? My name is Ray Liao, and I'm serving as legal counsel to the City Council this evening for purposes of this SEPA appeal hearing. So the question being, is there any more that the council needs to do in light of this disclosure regarding this email communication? Well, with regards to any arguable ex parte communications, the opportunity by the parties to rebut any of those comments has now been put on the table. and with Councilmember DeMichel's assertion that she is able to proceed in this hearing on an unbiased and without prejudice going into the ultimate decision in terms of any concerns regarding appearance of fairness violations, at least from a legal perspective. I don't see any with those disclosures and that statement by council member. So.
People are mumbling and not speaking into the microphone.
I'm sorry, there's been a request in the audience for us to speak louder. We will certainly attempt to do that, and if we can get the volume turned up a little bit, perhaps, as long as we don't get feedback, that would be helpful as well. I'll try to use my stage voice. I did theater in high school.
Just yesterday.
Any questions or concerns from my fellow council members before we move on? Second, we will address potential conflicts of interests and disclosures that council members should make at this time. Do any council members have a personal interest, financial or otherwise, in which he or she stands to gain or lose by the decision? This would include prospective employment for any council member or his or her family as a result of this decision, competitive business relationships between the council members and any parties at the hearing, familial relationships between the council members and any of the parties at the hearing, council members owning or controlling property that is near the proposed areas of the zoning redesignation. Finally, have the council members made a final decision on the appeal before hearing any testimony or evidence or otherwise feel they could not be impartial in rendering a decision in this appeal? Seeing none, are there any objections to participation by individual council members that the parties intend to raise at this time?
Richard Aramber, here we go. Richard Aramber, representing the appellant Providence Point Umbrella Association. We have raised the issue of the email sent by Councilmember DeMichel. The email that was sent referenced all 8 parcels that were being considered by the council in this activity. So we continue to indicate to the council that that Ms. DeMichel should not participate in these hearings because of appearance of fairness considerations.
I will ask our legal counsel, the council's legal counsel again, where we stand. I am but a humble rocket scientist.
Again, unfortunately, the council doesn't have established procedures in terms of what as a body should be done as a next step. If council member DeMichel is does not feel that she's in a position to need to recuse herself because she feels she can be unbiased and impartial in proceeding tonight and being a member of the council body making this decision, that's a decision that she can make. The council can take it up in discussion if you have concerns, but the objection's been lodged. And it would just remain on the record if Councilmember DeMichel chooses to remain on the dais and participate in this proceeding.
Councilmember Winterstein.
Question for council. We heard certain dates and certain events related to those dates. Could you clarify for me the relevance of the timeline that was given?
It's my understanding that the email was lodged prior to the outset of the filing of the notice of appeal. So September was the date, I understand? September 20th, and the appeal was filed on October 22nd. So with respect to this quasi-judicial proceeding, any communications, at least, that occurred at that point in time predated the existence of this appeal. So the only thing left on the table because that's really not an ex parte communication because this proceeding didn't exist. With respect to any bias that Councilmember DeMichel has, that's really a judgment call. We've heard from the council member that she is not concerned with respect to bias. To my understanding, her comments had to do with a legislative action that will be before this council that is not subject to the appearance of fairness doctrine. What is subject to the appearance of fairness doctrine is the SEPA appeal determination. So it's quite possible to support that legislative action, but to take an opposite decision with respect to the SEPA determination that is preceding that decision.
Thank you.
So having heard the concerns raised by the appellant, is there anyone who wishes to address this further, or shall we move on? I see a will of the body to move on at this point. We will move to discuss. I'm going to summarize the proceedings with the parties. We're going to have introductory and opening statements. Each side will be allowed up to 5 minutes. We're going to have direct testimony, cross-examination, and redirects. We understand the city intends to initially call 2 city staff members as witnesses, and that the appellant will not initially call any witnesses, but will question the city's witness in both direct and cross-examination. Is this still correct?
That's correct.
It is also our understanding that the school district will call 1 witness.
That is correct.
Finally, we understand that the parties will try to limit the total time for each witness to 30 minutes. Is this correct?
Yes.
That will be the attempt, yes, excuse me.
I'm going to ask the city clerk and legal counsel to provide time checks throughout each witness to help the parties to be mindful of this agreement. Rebuttal testimony, cross-examination, and redirects. We understand the appellant has up to 3 potential rebuttal witnesses, and the school district has 1 potential rebuttal witness. Is that correct?
Yes, the calling of those witnesses will be dependent on the testimony received.
We will need to address available time for rebuttal at the close of the parties' cases in chief. The council only intends to hold 3 hours of proceedings tonight. When we get to closing arguments, each side has been allowed up to 5 minutes. And finally, in regards to council deliberation, depending on where we are in the evening, the council may close the hearing tonight and conduct deliberations at a special meeting. Have the parties stipulated to the entry of any of the pre-filed exhibits?
Again, Richard DeRamber representing the appellant. The council have met and we have pre-filed exhibits that have been submitted, and I understand there is no objection to the receipt of those exhibits by the council.
James Haney representing Director Niven and the Development Services staff. That is correct. We have agreed on exhibits. I believe the city has 10 exhibits, and then there are exhibits that the other parties have submitted, and we have no objection to any of the exhibits.
Jessica Skelton, counsel for Issaquah School District, and we agree, we so stipulate.
Thank you. Any exhibits to which the parties have not stipulated and any new exhibits will need to be introduced during the hearing. At this time, oh, no, we won't do that part yet. So I believe we will now move into opening statements. Again, I will remind all parties that these are limited each to 5 minutes, and we'll start with the appellant. Oh, I'm sorry. Councilmember Goodman.
Is there a time that we can ask some procedural questions?
Always.
Sure.
I think they're always in order.
Oh, okay.
From the dais.
Okay, thank you. So my first request is that we have folks that are sitting at the table identify themselves. And then my second question is I don't quite understand if the Providence Point Umbrella Association is the appellant and it's appealing a city decision. I'm not quite sure what the role of the school district is in this proceeding. So if somebody could clarify that, please.
I will turn to the council's legal counsel on this question.
I will let the parties introduce themselves. It is my understanding, and I will let the school district speak for themselves. This school district was invited to participate in this appeal proceeding. as the party that initially owns the property, and what that seems to be at greatest issue in this appeal proceeding. It's my understanding that initially the appellants requested that the school district file a motion to intervene in this proceeding, but did not proceed with filing that motion and has effectively stipulated to their participation. Beyond that, I would leave it to the school district to introduce their interest into this appeal.
The appellant to explain too. Thanks.
I will just say towards the question of when we have procedural questions or question of content, I'm going to say that we should probably not interrupt the opening statements, but as we get into testimony from each person, I will offer counsel the opportunity to ask substantive or procedural questions as we go, as we hear from those witnesses. And with that, I will open the opening statement to the appellant.
Well, introductions first. I'm Richard Arambrew. I'm an attorney. My office address is 720 3rd Avenue in Seattle, and I'm here tonight representing the Providence Point Umbrella Association, the appellant. Seated to my left is Dave Weckner, land use planner retained by the appellant to provide testimony. Already has provided testimony to the Planning Commission. He may provide additional testimony tonight concerning the SEPA aspects of this appeal.
Would you please proceed with your opening statement?
Okay. Thank you. And kind of contrary to what Mr. Martz has indicated, please feel free to interrupt me during my opening statement if you have some questions about the things that I'm saying, the positions that I'm taking. This is a SEPA appeal, and we've had SEPA, the State Environmental Policy Act, as a part of our fabric of our environmental laws since at least 1971, when the legislature decided there needed to be additional environmental consideration of projects. And at that time, projects proceeded ahead with, based on economics, on other factors, technical factors, but legislature indicated that we needed to really take a close look at the environmental impacts. So what's before you tonight is a SEPA appeal, but what is really before you is a proposal by the Issaquah School District for a comprehensive plan amendment and a rezone from the current single-family low-density designation for 40 acres of property off of 228th to capital facilities which would permit them to build, which they make no bones about, a high school, an elementary school, a stadium, and all the accoutrements that go with such facilities. There is a question, and Councilmember Goodman raised the question, and I will raise it again, about who the real applicant here is. We've raised it as a part of our appeal. We continue to consider it a matter of concern because the real party in interest here is the school district, not the city, who has been posed as the applicant here. Fundamental question here is whether or not the environmental checklist and the review that's been done to date has been adequate, whether there have been adequate consideration of the environmental impacts of this substantial project, one of the largest projects in the city, as a matter of fact. The checklist that was done is, I'm trying to be charitable here, a model of generality, of ambiguity, and does not contain any specific consideration of the plans of the district. The district has said, well, we don't really know what we're going to do, and I'm sure you've had a chance to read the briefs, and they said, well, we're really not sure. We've got $120 million we've got to spend, but we're not sure how we're going to spend it. Truth of the matter is that they intend a 1,400 student high school, 215,000 square feet, 3 stories high, a 600 student, 73,000 square foot elementary school, a single access off of 228th with the traffic light, a sports stadium, associated construction, and all the parking that goes with this. These facilities, the high school and the stadium, cannot be built without this rezone. Next door to these facilities is the Providence Point Retirement Community, 1,000 units with approximately 1,400 residents that has been here since 1982-83. The impacts on the Providence Point community are substantial and clear along a 3,200-foot boundary between the school district site and the Providence Point community. The council's urged to just kind of kick this can down the road. Let's not worry about things now. We'll do our review later. Truth of the matter is that once this rezone is done, the code kicks in, and we are starting to look at criteria that include 7-foot setbacks, 65-foot building heights, 90% impervious surfaces. Anybody who's been in this community knows what the impacts of the high schools are. They need to be carefully considered, and they have not been properly considered by the staff, and we'll get into some of the questions and answers that have been resolved here, or not resolved. In many ways, the city's review here has been disrespectful of the Providence Point community and the refusal to consider those impacts on the community. That concludes my opening statement, right at 5 minutes.
Thank you very much. I'll now ask the City Legal Counsel to formally introduce himself and then give his opening statement.
Thank you, Council President Martz and members of the council. For the record, my name is James Haney, and I represent the city's SEPA responsible official, Keith Niven, and the Development Services staff in these proceedings. Mr. Niven and Ms. Heinen are seated at the table, the staff table, and they will be the witnesses who will be testifying this evening on behalf of the city. What you have before you tonight is a narrow issue. You have before you the issue of whether or not the determination of non-significance that was issued in this matter, and that is Exhibit C10 in the record, was properly issued by the SEPA responsible official. You're not here to discuss the merits of the site plan and to rule on the merits of any site plan or any specific development of the school district property. That's not before you. You're not here to rule on the comprehensive plan designation change or the zoning map change from single-family small lot to community facilities. That's not the issue before you tonight. The sole issue before you is whether or not the city SEPA responsible official properly issued the determination of non-significance for environmental reasons. There is a burden of proof in these proceedings, and we pointed it out in our brief. The burden of proof is always on Providence Point in these proceedings to prove that Mr. Niven's determination was clearly erroneous. And that means that you, after considering all of the evidence here, have to determine that you have a firm and definite conviction that Mr. Niven made a mistake here. And that's the burden of proof. That's what you should be looking at and thinking about as you listen to the evidence this evening. Our position in this proceeding is, in a nutshell, is fairly simple. First, what is being proposed for the school district property at this time is a comprehensive plan designation change and a zoning map amendment. There is no site plan before you. There is no specific development before you. What we have in terms of existing comprehensive plan designation and zoning on the site is single-family small lot, which allows as permitted uses elementary schools, middle schools, and junior high schools, and it allows baseball, soccer, and football fields that are used and open to the public. The comprehensive plan designation change and the zoning map change will allow a high school. So in addition to what is already allowed in terms of school uses on the property, elementary schools, junior high schools, and middle schools, a high school is allowed under the CFF zoning. Also, the CFF zoning would allow a high school to have a high school stadium rather than a baseball, soccer, or football field that is open to the public, which is already allowed under the existing zoning. Our position is that this is a fairly incremental change in the zoning that does not have significant adverse environmental impacts, and that any environmental impacts that will occur as the result of site development can be dealt with at the site development stage. Mr. Niven and Ms. Heinonen will testify this evening. Ms. Heinonen will testify regarding her preparation of the checklist, and Mr. Niven will testify regarding his review of the checklist and his issuance of his environmental determination. Based on that testimony, we're going to ask you to uphold the decision of Mr. Niven to issue the DNS and to proceed to consider the merits of those other actions. But those other actions are not before you tonight, and the merits of any particular site plan or development of the site is not before you. Thank you.
Thank you for that. I'll now ask representation for the school district to formally introduce herself and to give her opening statement.
Thank you. My name is Jessica Skelton, and I am legal counsel to Issaquah School District number 411. And seated with me at council table is my partner, Denise Stiffarm. And I'll just quickly address the district's participation in this proceeding first before moving into my opening statement. As a special counsel to the council mentioned, the district was invited to participate based on its due process interest in property that it has possession and use of. Appellants raised a question about that, and we resolved that issue in a pre-hearing conference, and so the district is a participant here tonight. And also, before I get started, I have a handout I'd like to use for my opening statement. I'd like to offer it as an exhibit.
I believe the request was for 11 copies of materials. Do you have 11 copies?
So this handout is two sections of the Issaquah Municipal Code and then a chart drawn from a third section of the Issaquah Municipal Code, and I'd like to offer it as an exhibit in this proceeding.
City has no objection.
Please proceed.
Thank you. We're here tonight because appellants have confused environmental review of a docket of proposed comprehensive plan amendments with review of a specific project proposal. Here, the city properly determined that there were no adverse environmental impacts from the proposed comprehensive plan amendment and properly issued its DNS. Appellants focus on one particular proposed amendment, the redesignation and rezoning of the Providence Heights property from single-family small lot to community facilities. But the city properly determined that this change did not intensify the use of that property in a way that would cause significant adverse environmental impacts and properly issued its DNS. Unable to meet their burden to establish that the city's decision was clearly erroneous, as counsel for the city indicates that the standard of review is here, appellants instead suggest that the city was somehow obligated to review specific project plans that the district has for this site. You'll hear tonight from the district's chief of finance and operations that no such specific project plans exists. At this point, the district has developed only conceptual feasibility drawings related to the site and has no specific plans. In fact, as you'll hear tonight, there have been over 50 iterations of those conceptual plans that the district has considered up to this point. There simply isn't a possibility for project-specific review here, and recognizing that the SEPA responsible official correctly reviewed the comprehensive plan amendment and not a specific project proposal. I'd also like to direct the council to some of the legal authority that guides your decision. I know that may not be something that you look at every day, but in particular, I'd like to point you to a couple of cases that the district cited in our pre-hearing brief. And tellingly, counsel for the appellants have not discussed or distinguished those cases in any way. And those two cases are the Narrows View Preservation Association and Hayden cases, in which the Washington Supreme Court held that when there is a non-project zoning change with no specific plans for development, it is proper to issue a determination of non-significance. An EIS is not required, particularly when there's an opportunity at a later stage to require an EIS if warranted. And that's precisely what you have before you here today. You have a situation where the city was asked to review the impacts from a comprehensive plan amendment and not the impacts from a specific project proposal, and under the guiding case authority, that is correct. The cases cited by the appellants in this case all concerned situations where there was a substantial intensification of the use of the property as a result of the action at issue, and there were clearly established environmental harms as a result of that intensification of use, and that is not what you have before you. As counsel for the city indicated, the change in use here is from a single-family small lot zoning designation to a community facilities designation, and that's where I want to point you to the handout that I provided you. First of all, Issaquah Municipal Code Section 1806090 talks about what the community facilities designation is, and in particular in subsection E3 discusses that it's used for public property that has come into public ownership, and that's the reason why that property is being considered for that reclassification, for that redesignation. If you turn back to subsection A of that section of the code, it talks about how the community facilities designation is designed for compatibility of land uses. If you turn to the next statutory section, which is IMC 1807480, this is the community facility standards. This council may recall that just 2 years ago in 2017, you adopted amendments to these standards that are specifically designed to try to ensure compatibility, particularly for school siting, and to make that process more streamlined in light of increasing densification of the city of Issaquah. And finally, if you turn to the last page of this packet, it talks about the types of uses that are allowed under the single-family small lot zoning designation and the community facilities designation. This isn't all of them, but it really highlights for you the similarities that are allowed within those two zones and underscores the fact that there is not an intensification of use here that would necessitate further environmental scrutiny. So for that reason, the city properly issued its DNS, and we would ask that you affirm that determination. Thank you.
This is Clerk Eger speaking. I'd like to note that that was submitted as Exhibit S7.
Thank you. This is the point where, by agreement, we would ask for whether there's any direct testimony by the appellant witnesses. I believe you had said you do not, will not be presenting any witnesses this evening?
Well, that's not precisely true. In our pre-hearing conference with Ms. Liao, we attempted to streamline things for the council, recognizing that we would, in fact, be here at 8:30 or 9 o'clock at night. So the agreement was that we did intend to call Ms. Heinen and Mr. Niven, but to expedite things, they were also city witnesses. So the understanding was that the city would call those witnesses, ask them their questions, and then we would proceed to ask questions. And it was understood that we would not be bound by the usual legal procedure that cross-examination questions are limited to the scope of the direct examination. So that's the way we're going to proceed tonight. It would be an error to say that we do not have any witnesses. Those two city witnesses are our witnesses.
Thank you for that clarification. We're going to move to direct testimony by city witnesses that will also be appellant witnesses at this time.
Thank you, Council President Martz. The city would call Trish Heinonen to stand. I believe that the witnesses need to be sworn for this to be a SEPA hearing. I don't think that the witnesses have been sworn at this point, so I'd raise that as an issue. Is that something that we can have?
I think we'll probably need.
If we need to, and if there's no objection, I'm a notary, so I could swear in the witnesses if you would like me to do that.
We have no objection to Mr. Haney doing that.
No objection from the district.
Thank you for that offer. We will accept it.
Thank you. Ms. Heinonen, would you raise your right hand? Do you solemnly swear that the testimony you're about to give will be the truth and nothing but the truth?
I do.
Thank you. Ms. Heinonen, would you please state your full name and give your position at the city?
Trish Heinonen. I'm the Long Range Planning Manager.
Okay, see, I got it wrong, Heinonen.
It's common.
Thank you. Ms. Heinonen, would you please tell us what your duties are as Long Range Planning Manager?
Long Range is in charge of comprehensive plan amendments, housing strategies, code amendments, annexations, mostly legislative types of projects.
And what training and responsibilities do you have with respect to the State Environmental Policy Act?
I was trained about 10 years ago from our responsible official as he was trying to get more help in his SEPA work, so I was trained 10 years ago.
Would you say that you use SEPA on a regular basis?
Not often, but only for our non-project comprehensive plan amendments and code amendments.
So would it be fair then to say that with respect to the long-range planning duties that you have, comprehensive plan and zoning map amendments, that you do engage in SEPA review regarding those?
Yes.
Now, in this particular case, relates to the 2019 comprehensive plan and zoning map amendments. Were you responsible for shepherding those amendments through the city's process?
Yes.
The amendments, or the docket for those amendments was originally established in February of 2019, is that correct?
Yes.
And I believe there are some exhibits in the record, C1, C2, and C3. You're familiar with those?
Yes.
And was that the February 19th docket?
Yes.
Now, the initial docket did not include the school district property in Providence Heights, is that correct?
Correct.
And why was that?
It's my understanding the school district felt they would not have ownership of the property by the end of 2019, so they chose not to put it on the docket at that time.
So how did it come to be added to the docket?
The school district sent an email to Keith Niven in May saying that they had started eminent domain proceedings and hoped to take ownership of the property before the end of the year and requested that we start to process a rezone.
And I believe that email is Exhibit C4.
Yes.
Can you tell us then how it got placed on the docket?
We brought it back before the city council and they approved adding it to the docket.
Now, did you require the school district to file an application for the comprehensive plan amendment and rezone?
We did not.
And so who did you consider the applicant to be for the comprehensive plan amendment and rezone for the school district property?
All of the comprehensive plan amendments and rezones are, the city is considered the applicant.
And why is that? Why does the city consider itself the applicant on matters such as this?
Because they're legislative and not project specific.
If a person had come in with a project-specific rezone or comprehensive plan amendment, would you, or comprehensive, or project-specific rezone, would you have required them to file an application?
Yes,
But you didn't consider this to be a project-related rezone?
correct.
And why is that?
Because they were a public entity requesting a change for public purpose on the site, and that was consistent with the community facilities zone.
Is there anything that you're aware of in the Issaquah Municipal Code that requires a property owner to be the applicant with respect to a comprehensive plan amendment change?
No.
Would it have been made any difference in the way that you processed the 2019 comprehensive plan and zoning map amendments if the school district had been the applicant?
It's my understanding that the school district would have been their own SEPA official, and they would have done their own checklist and their own designation if they were the applicant.
So having the city be the comprehensive plan applicant and zoning map amendment applicant actually gave you the ability to do SEPA, is that correct?
Correct.
Did you prepare the environmental checklist for the 2019 comprehensive plan amendments, which is
I did.
Exhibit C8, I believe?
I did.
Did you have help in doing that from anybody?
I did not.
Over the years, how many environmental checklists would you say you've prepared?
Probably more than 20.
And are you familiar with the difference between a project environmental checklist and a non-project environmental
Yes.
checklist? Can you tell us what that is?
Project SEPA is much more specific. You have a site plan, you have something that's the city has accepted to do your environmental review on, and there's a lot more specificity to that environmental review than what I do is non-project specific, and it's phase one of the two-phase SEPA review that the city does. So mine is much more general, much more looking at them in the big picture, whereas then when a project review development agreement or development application comes in, that SEPA at that time is very specific.
The checklist has a number of questions on it, does it not, that are kind of site-specific questions, like how many parking spaces a project will have, how many people will be employed by the project. Do you know those questions?
Yes.
On a non-project application or a non-project action such as this, would you fill out the environmental checklist and those specific questions?
What I do is I reference that that we don't have any information at this time in the phase one of the SEPA review, and that the actual review of those details will be done at the project, when the project is submitted.
So it sounds like you're saying there is phased review, that you were using phased review in this case.
Correct.
And there's two phases, if I'm hearing you correctly?
Correct.
Can you say what those two phases are?
The first phase is legislative review, and that's the big picture review that we did on the comprehensive plan and zoning map amendment. And then if that goes further, then the applicant will come in with a site plan and all the details like parking spaces and square footage, height, all those. And then another SEPA checklist will be done, and another SEPA determination will be done at that time, and that's phase two. That's the very specific SEPA review.
Now, you understand that in this particular case, the appellant, Providence Point Umbrella Association, is saying you should have reviewed a site plan, which appears on the city's website, I believe. You understand that?
I understand that.
Did you review that site plan and use it in the preparation of your checklist?
I did not. That wouldn't have been our phased review. That wouldn't have been consistent with that process.
So when you were answering the questions on the checklist that were regarding site-specific things, you were looking at them more on a cumulative basis as opposed to on the site-specific basis?
Correct.
And do you have an understanding, Ms. Heinonen, about whether or not under the GMA there are any requirements to deal with the cumulative effects of comprehensive plan amendments when you're reviewing them?
Well, I think, are you alluding to item D on the checklist for a non-project?
Well, I guess what
Is
I'm
that-
asking is the GMA talks about processing comprehensive plan amendments no more than once a year, correct? And do you understand why that is, that you're supposed to consider them together?
Right, so that piecemeal amendments don't come throughout the year and then have a big effect piecemeal that you didn't look at as a total.
So when you were filling out this environmental checklist, were you looking at everything as a total, or were you looking at each individual site that was proposed to be rezoned?
Everything as a total.
Did you also fill out the non-project supplement?
Yes.
And what is the purpose of that?
That allows you to look at the different elements of earth, air, water, holistically to see if the proposal changes those either faster or more intensely versus if the proposal did not go through. And since so many of the permitted uses are already permitted in the zones, it didn't seem like anything was being changed faster or more intensely with the proposals that were given.
So you were looking at the impacts of the zoning and comprehensive plan amendment change?
Correct.
And would you characterize the comprehensive plan amendment and zoning map amendment here as making a significant difference in the number of allowed uses or nature of allowed uses on the site?
No.
I don't know quite how I make an objection here, but I'm going to make one. I appreciate these are administrative proceedings, but these long leading questions that essentially provide the answer to the witness, I think, are inappropriate. And I'd ask counsel to not ask leading questions of this nature, if I may.
Well, Mr. Ramberg, if I had more time rather than a half an hour to get in her testimony, direct testimony, your cross-examination, and the district's examination, I would be taking a lot more time doing this, but I'm trying to truncate the proceedings. So
this is our first objection, and I'll use this as an opportunity to ask our counsel what the model is for the 7 of us to address objections.
Generally speaking, on direct, counsel typically should not ask leading questions of their own witnesses. So in standard protocol, you might ask the city council to try and abbreviate his lengthy questions, notwithstanding the issue and concern of time.
That would be the city's council, not the city council, which.
Thank you.
But thank you for that advice, and I will ask the city's council to ask more abbreviated questions.
I will attempt to do that. Ms. Heinonen, in this appeal, it's alleged that your use of the words "not applicable" or "does not apply" in response to some questions was error. Do you have an opinion on that?
I don't agree that they were in error.
And why is that?
Because in a phased SEPA review, you look at the big picture and not site-specific issues. And that's what the checklist does.
And how did you deal with these broader issues in the non-project supplement?
I knew that the land use code, critical areas ordinance, setbacks, height, noise, lighting, I know those are all covered in the code, and when the project, if and when it does come in, those pieces will be used to evaluate the site plan at that time.
And this is your analysis relating to those code sections contained in the non-project supplement?
Correct.
Ms. Heinonen, do you believe that the checklist you filled out on the 2019 comprehensive plan and zoning map amendments was sufficiently complete?
Yes.
And do you think it was adequate for environmental review by the director?
Yes, I do.
Is there anything else you want to add to your testimony that I haven't asked you about?
Not at this time.
Then I have no further questions for Ms. Heinonen.
Thank you. And per the agreement that was mentioned earlier by the appellant, I believe that the next step is going to be direct, what's the right word to use here? It's not cross-examination at this point, it's direct. It's a hybrid between cross-examination and direct.
And when will I know to object and Mr. Ramper is leading questions? Can you tell me which questions are direct and which ones are
I believe that,
cross?
I believe I read someplace, the witness is yours.
Thank you. Leading questions don't apply to adverse witnesses. So, Ms. Heinonen. Let's not kid ourselves here. Why is the school district asking for these comp plan changes and rezones?
Objection calls for speculation.
What is the standard for an objection on calling for speculation?
You might ask the council to rephrase the question in a manner that would not call for speculation.
May I ask that you rephrase the question in a way that does not call for speculation? Oh, I'm sorry, I looked at the wrong person.
Do you know why the school district is requesting the comp plan and rezone here?
In the email, it said they were hoping to put a school on the site.
Do you know if they're intending to put a high school on the site?
That is my understanding at this time.
Can they put a high school on the site without the comp plan and rezone change?
No, it is not a permitted use in single-family small lot.
So in terms of your review, there would be should you not be considering the impacts of something made possible by the rezone?
In phased review, that's not what my checklist was to do. That would come later when the application and a site plan comes in for a school. That would be evaluated at that time.
But without the rezone, there would be no site plan request by the district for a high school. Isn't that correct?
Correct.
Okay. So the rezone is a key to the land use on this property. Is that correct?
Correct.
Okay. And why wasn't this simple fact of the intention of the school district presented in your checklist?
In phased review, the site plan doesn't come into play. That comes into play during the second phase of phase SEPA review, where a specific site plan that's been accepted by the city is reviewed very specifically for all of those possible impacts.
Is it possible for you to review the impacts on this property of locating a high school in that location?
Not without a site plan. And when that comes, we will look at it specifically when we have a site plan that's been accepted by the city.
But without the rezone, there isn't going to be a plan for a high school, is there?
It's my understanding, yes.
Oh, okay. Now, one thing that's confused me about this process is who the applicant is. I'm told in your checklist that the city's the applicant.
Correct.
And who's the city for this purpose?
I don't understand who's
I mean, the city has a mayor, and the city has a council, and the city has an administrator, and it has a city attorney, and it has you as long-range planning. Who's the applicant here?
I would say it's the administration. It would be all of us.
And how was the decision made by the administration that the city would be the applicant?
The way that our phased review is done, the city is the applicant for all of them because it's a legislative action. When it becomes a specific action, any property owner would have to come in and apply for that development permit, and then they are the applicant. But in this first phase, the city is the applicant.
But absent the request from the school district, to do the comp plan and rezone change, the city would not have done this on their own, would they?
Objection calls for speculation.
Same advice to phrase questions in a form that does not.
The question.
Councilmember Goodman.
Yes.
Procedural question.
So I guess my procedural question is, who makes a decision about whether to sustain or overrule objections? Is that the council president? There are
That is
procedures.
all of us. That is the 7 of us.
Okay.
So
Okay, so we've had now three objections, and we've had advice from council, and so I'm wondering when it is the council weighs in on whether we get to vote on whether to sustain or overrule objections.
I'm sorry, I had gone with the advice of our legal counsel without looking to my.
It's a question. I don't know the answer. It's a question.
Kind of in no man's land with procedure, so however you, as a council, decide to make that. So, if you decide to vote on every objection, you can do that. If you decide to defer to the council president, it's your call in this proceeding.
So what I will do on future objections is I will first ask for advice from our legal counsel, and then I will turn to my fellow council members and see if there is any objection to taking that legal advice. And if there is objection, or if there's a wish for further discussion, we will discuss it, and if there's not, I will generally defer to our legal counsel.
Thanks.
Thank you for asking this question. So on this one, your advice?
I think I would give the same advice prior.
Can you repeat what the question was, and then the objection and the recommendation, or the advice, please?
I honestly cannot remember the question. I remember the objection calls for speculation, so the advice was to ask for the question to be rephrased in a manner that would not call for speculation.
What was the question?
We've been around, and I don't have the question in mind. Let's move on. I think would be best.
Noted.
Noted.
Do you understand that the school district wishes to put a sports stadium on this property?
Same objection calls for speculation. This witness does not have knowledge about what the school district wishes to do.
The question was whether she was aware. That's not speculation.
Wait, okay, so.
The question was whether she's aware. That's not speculation.
So please answer the question.
I am aware.
And in the checklist, did you, well, let me put it this way. Is a stadium permitted in the current zoning?
No, it is not.
And did you consider the impacts that a stadium might have on the adjoining properties in your SEPA review?
I did not, because phased SEPA review, the first phase does not qualify those specific sorts of impacts because there is no accepted site plan to make those judgments from. That will happen when we have an accepted site plan to look at for specifics.
And you aware generally of what high school stadiums in the Issaquah School District look like?
Yes.
And would it be possible to analyze the impacts of things such as light and noise and traffic congestion from such stadiums?
It will be once we have a site plan.
But you can do that now, can't you?
What would we base it on?
You would base it on the model for stadiums that are found in the Issaquah School District.
I believe all 4 of them are different. I don't know how we would do that, and that's why we do phased review, so we can look at the general impacts and then the specific impacts when we actually have a specific site plan to review.
But again, no specific impacts unless the rezone occurs for a stadium, correct?
I don't think I would.
No stadium is possible, no sports stadium is possible on this site without this rezone. Isn't that correct?
Correct.
So if the rezone is not adopted, there will be no sports stadium.
Correct.
Okay. I think Mr. Haney asked you if cumulative impacts are required as a part of the SEPA review of comp plan changes, the annual comp plan changes.
Yes.
Is that correct?
Yes.
And can you tell me in the checklist, can you point me to a place in the checklist where that cumulative review has taken place?
I believe it's the whole checklist taken completely is where we show that it's consistent with the comprehensive plan, with the uses that are provided for. I believe part of it's in D, which is non-project, the non-project part.
Do you have in mind the size, are you aware of the size of the high school and the elementary school that would be placed on the site?
No, not specifically.
You've not considered any of that?
No, I have not.
You have no information?
It's not that I don't have the information, it's that in phased review, we don't look at that sort of information. That is in the second phase of SEPA review, when we actually have a site plan that's been accepted by the city.
But you are aware, are you not, that the plans submitted in the project narrative by the Issaquah School District include a 215,000 square foot high school, 3 stories in size, to serve 1,400 students?
I have not looked at them closely, no. I'm not aware of all those numbers.
That's not the question of closely. Are you aware that that is the plan that's been proposed?
I'm not aware of the plan that has been proposed. I've heard it's changed many times, so I don't know what the current plan is.
The size, the square footage, height, the number of students, has that changed?
I don't know, has it?
Well, if you don't know, Ms. Annan, I'm curious about some of these questions, the answers that you have in the checklist. Let me refer you to question 8, and I'm going to read it so we don't have to struggle through things here. It says, approximately how many people would reside or work on the completed project? Now, did you answer that question for the proposed high school and elementary school?
No, because I don't know how many would. That would happen in the second phase of SEPA review when we actually have a site plan.
So if that's the case, why did you say approximately 37,590 people currently reside within the city limits?
I was giving a global response showing what the existing conditions are now.
The existing conditions don't relate to the entire city, do they?
I think they do, yes.
I'd like to advise council, we're at 12 minutes now. If you want to maybe just take a couple more questions. Mr. Haney was able to get his questions done in 12 minutes, so maybe a couple more. In the spirit of trying to get through each witness in a half hour per the earlier terms.
Well, this is my witness as well, and I would object to putting stringent time limits on us during the course of this appeal, if that's your intention.
So noted.
Did you consider the stormwater impacts of development of the Providence Point or the Providence Heights site?
No, those will be considered when a site plan comes in and the second phase of SEPA review.
And did you have an opportunity to review the site and circulation plan that was on the city's website?
No, I did not.
And just another question about kind of who's on first here. Are you here tonight testifying for the city staff or as the applicant?
I would be both.
So you're both the city staff and the applicant?
I believe I'm both.
And the cumulative impacts, did you consider the cumulative impacts of development of the Talus site?
No, I did not. I did it in a general way. Again, there was no site plan for us to look at in phased review. We looked at, is a school an appropriate use in that area? And it fit those requirements. And so we did the same review as we did for the Providence Point site. Very general, very legislative as phase 1.
Okay, we'll try to keep to time limits. That's the questions I have.
Thank you very much. At this point, I would like to offer cross-examination by the school district of this witness.
Thank you. I just have one or two questions for you. Mr. Aramburu, counsel for the appellants, asked you whether the desire to site a high school on the properties was a basis for the CFF designation. Isn't another basis that the property has come into public ownership?
Correct.
That's all I have.
Thank you. At this point, I will offer redirect to the city's council.
Thank you. Ms. Heinonen, Mr. Aramburu asked you about a high school and the zoning change being necessary to allow a high school. What school uses are allowed under the current zoning?
On elementary school, junior high, and middle school, plus outdoor baseball, soccer, and football fields that are used by the public are all permitted uses now.
Okay, so let me ask you first about the school uses. Do you consider the change that would allow a high school to be a significant use change for the property?
No, not significant.
And why?
I'm sorry, we're not taking audience comment at this point. Please.
And why, Ms. Heinonen, do you believe that it is not a significant change?
Because we now have a high school in a single family that's adjoined by single family neighborhoods. We have code in place for noise, lights, transportation. We have all those land use codes in place that would help us to site such a facility with the least amount of impact to the surrounding neighborhoods.
And you mentioned Mr. Aramburu asked you about a stadium, and you mentioned that sports fields are currently allowed into the SFSL zone. Is that correct?
Correct. Baseball, football, soccer.
And just from a layperson's perspective, I guess, what do you consider to be the difference between baseball, football, and soccer fields that are open to public use and a stadium?
I'm not sure what the difference would be. I've been in both. They have lights, they have traffic, they have kids, they have adults.
You know, Council President Martz, I know I'm just at a point here of wanting to defend city staff. I understand that people's emotions are high here, but if you could at least show staff respect, and as I will show respect, and as I would urge you to show respect to all witnesses.
I understood, Mr. Haney. I just want to ask everyone, emotions run high in this issue. Please trust that this is a fair process and that we will get to a fair decision, and let the legal counsels for the appellant and for the city and for the school district put the best argument forward. I'm confident that if they believe that there's a legal argument to be made in regards to a witness, they'll make it. Thank you.
Thank you. I have no further questions for the witness.
All right, with that, you are, what's the word? You're released? Sure, released. We will move on to the city's second witness.
We'll call Keith Niven to the stand.
And as Mr. Niven comes forward, I'll let people know, in case anyone's wondering, we will around 9:30 take another 5-minute bio break. So if you're trying to figure that out, you got 24 minutes, roughly.
You need a list of the exhibits that are available.
Thanks.
Mr. Niven, do you solemnly swear that the testimony you're about to give in these proceedings will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Niven, would you please state your full name for the record, and would you tell us what your position at the city is?
Sure. My name is Keith Niven. I am currently the city's Director of Economic Development and the city's Director of Development Services.
And in your role at the city, do you have a specific responsibility with respect to State Environmental Policy Act review?
I do. So SEPA is adopted by reference in the city code, Title 18, Chapter 10, Section 020. The responsible official represents the lead agency to ensure the SEPA rules are followed, to ensure the threshold determination meets the provisions of RCW 4321C, and to ensure that the procedural requirements identified in WAC 197-11 are followed.
You tell us, Mr. Niven, what experience you've had with SEPA over the years?
Sure. Let me start by saying that my background is I have a bachelor's degree in urban planning and a master's in environmental planning, and I've worked for over 32 years in local government, and I'm a certified planner for over 30 years. I didn't originally, I'm not a native Washingtonian, sorry. Moved here from Phoenix. So when I came here, I knew that I wanted to immerse myself in SEPA. So I took my initial job in Washington State was with the city of Auburn, and I worked solely working on SEPA review for the city for 2 years. Following that, I was hired by the city of Issaquah as part of the city's major development review team, of which I then became the program manager. And as the program manager for that group, I took over the SEPA duties for the MDRT, and then I took over as Development Services Director in 2015, and most of the SEPA decisions that come out of the city have my name on them.
Did you perform a role, a SEPA role, with respect to the 2019 comprehensive plan and zoning map amendments?
I did.
What was your role?
So my role was to ensure that the environmental values were considered during the decision-making process by the City Council. That's part of the comp plan docket, sorry.
So Ms. Hainen testified that she prepared the environmental checklist. Did you play any role in the development of the checklist in this matter?
No, I did not.
When did you receive the checklist from Ms. Hainen?
So the checklist is dated the 28th of August, but I received it on the 29th through an email.
Now, are you familiar with the school district property that's proposed to be redesignated in zone CFF?
Both of them, well, both. There's Providence Heights and Taos.
That's correct. When I refer to the school district property during my questioning, I'm going to refer to just the Providence Point or the Providence Heights property, since that seems to be the focus of the appeal. So how are you familiar with that property?
So I personally visited the site a number of times during the Providence Heights demolition permit appeal. That SEPA decision was also appealed. The hearing examiner remanded the decision to the SEPA responsible official to consider the landmark status of the property, which had not occurred, and it had occurred after we had issued the initial SEPA decision. So after reconsideration and reissuance of the mitigated determination of non-significance for the demolition of Providence Heights, the city's hearing examiner upheld the responsible official's MDNS for the demolition permit. That was my initial.
So just to be clear, you were the SEPA responsible official for that demolition project relating to the old Providence College, is that correct?
Yes, I was.
Did you play, what exactly was your role as SEPA responsible official relating to that site?
So it's my opinion that staff need to be familiar with property conditions to understand the potential environmental impacts that may result from a proposed action. I'm personally familiar with all the properties proposed for redesignation and rezone as part of this comprehensive plan docket. I've studied their relationship to surrounding properties on the city zoning map, looked at their aerial representation and relationship to adjacent properties using King County's IMAP, and have visited all of the sites that are part of the docket.
And what do you understand the specific proposal to be in the 2019 comprehensive plan and zoning map amendments for the school district property in Providence Heights?
The proposal is to redesignate the 3 school-owned properties to community facilities and zone the properties community facilities.
And what is the current zoning on the site?
The current zoning is single-family small lot, SF-SL.
And can you give us a thumbnail sketch, if you will, of the differences between the single-family small lot zoning and the uses allowed there and the CFF zoning and the uses allowed under that zoning?
Sure. So both zones allow for some school facilities. Single-family small lot allows for elementary schools and middle schools, as we heard earlier. Community facilities allows for these facilities as well as high schools, vocational schools, and colleges. Sports fields or stadiums for sporting facilities that would be part of an allowed school would be considered accessory to the use and would be allowed in either zone. And that is contrary to what my staff said earlier, but she was wrong.
So when you say it would be accessory, if someone were building a middle school or a junior high school and they wanted to put in a stadium, a school wanted to do that, would you consider that to be an allowed use, or would that require a rezone to CFF?
If the school district wanted to build a stadium or an arena, which is a defined term in the Issaquah Municipal Code 18-02, they could do that as part of a middle school under the current zone.
And do you have middle schools in this area that have sports fields like that?
We have middle schools that have sports fields. To my knowledge, none of them have stadiums, which are defined as a large open or enclosed place used for games and major events, partly or completely surrounded by tiers of seats for spectators. That's the definition in the city code.
Do any of them have viewing stands?
I am not sure if Issaquah Middle School has bleachers or not. I don't know. I apologize.
Is a high school allowed in the single-family small lot zone?
It is not.
So would a rezone be necessary to allow a high school?
It would.
Have you had experience in project review or review of other high schools in the Issaquah area?
Only, I want to say tangentially, but related to the addition of portables and the traffic issues surrounding Issaquah High School. But the high school itself predates me.
And does that school contain a stadium?
It does.
Does that stadium have lighting, or does that campus have lighting?
It does, and we are actually working through a lighting issue with the school district on the middle school. They have recently, as part of their remodel, installed lights around the field at the middle school, and we've had our lighting consultant go out with the school district to kind of dial in the photometrics to make sure that the night glow is minimized.
Would you say then you're familiar with lighting issues relating to high schools?
I believe I am, yes.
And would you also say you're familiar with traffic issues relating to high schools from your review?
Yes.
Do you have any current role with respect to a middle school proposed at Tallis?
Yes, I'm currently working with my plan review staff on the site plan that has been submitted for that site, which includes issues on traffic, parking, walls, and site coverage.
Just going back to the Issaquah High School, do you know was there any environmental review done of any of the things that you reviewed or were working on with respect to that site?
Yes, there was a project level review done through SEPA.
And did that project level review look at issues like lighting and traffic and things of that nature?
It did. A ultimately, the traffic signal at Second and Sunset was installed based on the changes to the schools in downtown.
Do you know if those issues were looked at the time the high school property was zoned for its current zoning?
I don't know that.
What about the Talus school? Was there environmental review done with respect to that?
So the environmental review is, the project level environmental review is happening now with the site development permit application that was submitted.
And are you aware of any environmental review that was done when that site was zoned, last zoned?
Oh, absolutely. There was an EIS that was done for Talus.
Can you explain to us the difference between a project action and a non-project action for purposes of SEPA?
Sure. A non-project action is something that is intended to be bigger picture. It is, it is to look at, typically it's for a legislative action, like a comp plan and rezone, adoption of new ordinances or programs. Those can all be examples of non-project actions. Project level SEPA considers the layout of the property, building height, setbacks, traffic study, stormwater study are all part of things that come in with the project level. And that's when you kind of roll up your sleeves and you really look at how the proposal is going to impact the environment and adjacent properties.
Mr. Haney, I'm going to give you the same note that I gave to Mr. Arambaru. We're at 12, 13 minutes. If you could just 2 or 3 more questions.
Okay, I will try to do that. Mr. Niven, can you explain why you did not review, the type of environmental review here that you did here, what's called phase review, as I understand it?
So WAC 197.11.065, basically phase review states a lead agency shall determine the appropriate scope and level of detail of environmental review to coincide with the meaningful points in their planning and decision-making process. And under subsection B, environmental review may be phased. If used, phased review assists agencies and the public to focus on issues that are ready for decision and exclude from consideration issues already decided or not yet ready. So I think that the WAC is really clear on what a phased review is and why we chose to do a phased review for this application, because there are certain things that are ready to be considered and thought through, and then there's others that aren't going to be ready until a site plan is actually submitted.
And what matters did you consider ready for review at this point?
So this is, everybody tries to make this as small as possible. This, for me, is about the land use change and the zoning change. And really, we have structured our community facilities zone and designation to be compatible with every surrounding zone, which is why there's single family near the high school now. But if you look at subsection A of 1807-480, which is called compatibility of land uses, under community facilities, it says establish general standards regarding aesthetics, height, and other development standards for community facilities which ensure compatibility of design, construction, and scale, and minimizes the impact of these facilities on surrounding uses. So the reality, so this construct that we have here, that community facilities is a compatible zone with other adjacent zones, is in our code now. And so as we talked about changing it from single-family small lot to community facilities, that is what I considered was we're changing it to something that's compatible with single family.
And what issues, may I just ask one more question? What issues do you consider not yet ready for review and that will be reviewed later?
So just to give you an example of how the middle school at Tallis is working, that initial site plan that they brought to us had basically Tallis Drive comes up, they had a stop sign coming out of the middle school, and that was their whole traffic solution that they were proposing. And we said, well, we don't think so. We think there was going to be a much bigger issue than that. So it went from a stop sign to a roundabout to a traffic light to a possible grade-separated traffic entrance. That was a lot of different iterations to go through. They spent a lot of money on traffic consultants to kind of walk us through all those different potential design outcomes. That level of detail review, looking at photometrics and looking at the impact that the stadium could have on adjacent residences. Need to know where the stadium is, need to know how tall the light fixtures are, need to know what's in between those light fixtures and those residences. There's all of those type of details going to come later during the master site plan review, which will come before this group.
Mr. Niven, before we move on, I have one question about something you said, and I'll also offer my fellow council members. You said that during the demolition FDNS appeal, it went to a hearing examiner?
So,
I still have my question. Why do we have a different process today and have the appeal coming to us rather than a hearing examiner?
It's because of your city code. So basically, the legislative action gets appealed. The SEPA gets appealed to here. That was an appeal of a demolition permit or a construction permit, which goes to the hearing examiner. So a different thing gets appealed to a different hearing body.
Even though it's all SEPA?
Yes.
Okay. Do any of my fellow council members, Councilmember Winterstein?
It was stated earlier in the Phase 1 review that there was a question and this was actually asked of Ms. Heinonen, that specifically in the Phase 1 review asked about a proposed project. So I'm confused why a Phase 1 review has a checklist question that identifies a proposed project.
So the checklist, the checklist has some errors in it. Question 9 in the checklist basically says that the school district has 2 projects in for permit review. That's not true. The middle school is in for permit review. Whatever is happening on Providence Heights has not been submitted for permit review as yet. So I think she was anticipating that it would have been submitted. It has not been submitted. Number of issues, obviously, and so if that was your question, Councilmember Winterstein, that would be my answer. If it was a different question, I might have missed it.
I'm not sure you answered my question.
Okay, let's go again.
Are the questions for a checklist defined ahead of time, or are they dynamic per docket?
No, the checklist is adopted by the city. So we have a standard checklist, okay? It comes with different environmental issues that need to be considered. So for example, earth, water, air, traffic, lights, housing, all those things are standard for no matter what permit comes through the door. When you're doing a non-project action, there's an addendum to the standard checklist, which is to consider different questions for a non-project action.
Okay, so there's a standardized list of questions, there's an addendum for a non-project one, and that's why there was a question considered in a Phase 1 review that has the phrase in there, proposed project.
I believe so.
Thank you for clarifying that.
Councilmember Ray.
So there could be in the future a master site plan, and at that point, we would do the Phase 2 review. What's the process for that review as opposed to the Phase 1 review?
Sure. So if the council approves the rezone and the redesignation, and supposing that the school district brings forward a plan for the use of that property, because of the number of acres it is, it's considered a master site plan and not a site development permit. Because that's a different thing, it has a different process than what a site development permit would have. A master site plan goes first it goes through city staff. So we will do the review, we will generate a staff report, we will send our staff report to the city's development commission. The development commission then will consider that staff report and ultimately make a recommendation to the full city council on that master site plan. It then comes to you guys. You guys are the final decision maker on a master site plan.
Thank you.
Councilmember Goodman.
Thank you. So the Phase 2 does not involve a SEPA checklist, or it does?
So, bless you. So Phase 2, Phase 2 is an environmental cleanup of a property. Can we call it project and planned action? So the project level review has an additional SEPA that needs to be done based on an actual plan. Here's where it's a little different. Because they are a public entity, the school district, my guess is unless they cede their SEPA lead agency authority to the city, they will assume SEPA lead agency authority on the project level SEPA review because they are a higher government than we are. They can do that.
On the, pardon the expression, on the Phase 2 for the master site plan, they would be the lead agency on that SEPA review?
Yes.
Okay.
The way that it normally would work, yes.
May I ask another question?
Please.
So what I heard you say about 1807-480, A1, compatibility of land uses, Jim Haney asked you a question about what would be ready for consideration. I think that was his question. What's ready to be considered now? And I understood your answer to be that you looked at that code provision and you said that, and I didn't quite understand the answer, but I wrote down that you said because it's compatible with adjacent land uses, that thus it's compatible. So could you, because it's kind of a circular answer, so I wanted to make sure I understood what you were saying.
Sure, thank you for that redirect. What I understood the question to be was, what did we consider? So what we considered was the general construct of our zoning code now and how community facilities is really, it allows for some different development standards. We did that through compact schools. But what I considered was the compatibility of CFF or CFF as an adjacent zone to Providence Heights. What I also considered were the public comments that came in through the comment period of the SEPA, which all of that, if you look at the final DNS that was issued, you will see cumulative impacts, possible alternatives, and potential project mitigation measures all identified as part of that final SEPA decision. And so hopefully that answers your question.
Well, it doesn't really. It sounds to me like your answer is that you considered the compatibility, and because the code says CF is compatible, then you considered it to be compatible with Providence Point, the neighboring property, because the code says CF is compatible.
From a zoning perspective.
From the zoning perspective.
Yes.
Okay, thanks.
Any other, Councilmember Ray, you look like you're doodling.
Well, it may be a slow one. Keith, you mentioned compact facilities. What is a compact facility?
So, so we changed our zoning code a bit ago. Maybe it's been a year and a half, recognizing that everybody in the city, whatever you were trying to build, we were running out of land. And so what we did is we put requirements on for things like minimum FAR, floor area ratio, structured parking. We basically, the half of all your parking needs to be in a structure that we passed for commercial uses and multifamily. We then said fair was fair and did that to the school district. And so the idea is the footprint of the facility overall could be smaller than what it had traditionally been before they started on their pathway to build these 4 schools that are in the pipeline right now.
Thank you.
Any other questions from council? So as promised, it's approximately 9:30, and so I am going to call a 5-minute bio break and then proceed with appellant direct and cross. 5 minutes. Let's be back at 9:39. Thank you. Mr. Arambaru, your witness.
Well, there's been a couple of questions, core questions. Without the rezone, there isn't going to be a high school on this property, correct?
Without the rezone, there won't be a high school. Was that your question?
Yes.
Sorry. Without the rezone or a rezone, there would not be a high school on the property.
Okay. Now, I just want to make sure I understand your testimony correctly. Are you saying that automatically any capital facilities rezone is consistent with the surrounding land uses? Is that what you said?
I'm saying that the capital facilities rezone is intended to be compatible with surrounding land uses.
So we're all just kind of wasting our time here then, aren't we? I mean, we don't, it's going to be automatically compatible no matter where it is?
I didn't say that.
Well, that's the question to you. Is it? Is that your testimony?
So my testimony is that, in my opinion, the community facilities rezone is compatible with the surrounding single-family land uses.
No matter where it is in the city?
I did not say that. I said this particular one.
This particular one. Okay. Now, and what information did you have about this high school that is proposed?
I did not have any information about this high school.
So how could you determine the high school is compatible if you didn't know what the high school was about?
I believe that whatever facilities are going to be proposed under whatever zoning the council determines to be on this property will be able to be successfully mitigated to be allowed on that property.
What's this mitigation you're talking about? What are we going to do?
We are going to mitigate whatever environmental impacts might be determined to be generated from the proposed land use.
Okay, how about traffic?
How about traffic?
Do you have any idea what the trip generation for this high school would be?
I do not.
Have no idea?
I have no idea.
Okay. And did you make any comparison with the existing single-family development of the property in terms of trip generation?
I did not.
Okay. So you don't know anything about the trip generation of this high school?
I do not. I have not seen a traffic impact analysis yet for this project.
Did you ask the school district? Any questions about their development, about what they were proposing?
I did not.
Send them an email, say, how big is this school going to be? What's it going to look like? Do you have any idea? Did you do that?
I already answered I did not.
Okay, okay.
You can ask again. I still did not.
Okay. Let's look at Exhibit P5. Could you put that up for me? Okay, this is one of the admitted exhibits. If you could scroll down a little bit for me. And just right there is good. Do you recognize this?
I do not. I've never seen this before.
Never seen it before?
Nope.
Okay. So this is Issaquah High School's new high school number 4. Do you know which one that is?
I've never seen this before.
I know. Do you know what high school number 4 is?
High school number 4 would be the high school that was anticipated as one of the 4 schools on their most recent bond levy.
I see. And do you know where high school number 4 is going to be?
I think they would like it to be on Providence Heights.
Okay,
site.
let's look at how the school district describes high school number 4. A new 240,000 square foot building, including core learning environments, a science suite, athletic facilities, community facilities, library, gym, commons, performing arts center, administrative areas, special services, building support services. Additionally, the project includes development of an all-weather turf athletic field. Is that what's going to be located at this property?
I have no idea.
Well, let's go on to the next sentence then. It says the proposed site is located at 4200 228th Avenue Southeast in Issaquah. Where is that?
I did not write that text.
Where is it?
So that would be the Providence Heights site.
Ah, the one you've been out to?
Yeah.
Correct, okay. Would you put up exhibit P 4.3, please? Do you recognize this drawing?
I've not seen that specific drawing. I have seen a drawing of a conceptual layout of the Providence Heights site. I don't believe I've seen that exact drawing.
I see. And the conceptual drawings that you've seen, do they all include a separate high school, a separate elementary school, and a separate stadium?
All the site plans that I've seen have included an elementary school, a high school, and a sports stadium.
Okay. And do all of the site plans you've seen show a single access off of 228th in the middle of the site?
I don't remember.
You don't remember? Okay.
No.
Would you put up exhibit P 4.4, please? Do you recognize this document?
I do not.
You've never seen this?
No, I have not.
Did you ever inquire of other people at the city as to whether or not they were considering or reviewing a site plan for the high school or other facilities on the Providence Heights site?
My staff have had a collaboration meeting, a feasibility meeting. It's a pre-application meeting with the school district on this site, which is where we got the site plan that was put on the city's webpage. That is all that we've had.
And as a part of that review, did you look at the project narrative?
I did not attend that meeting. My staff did.
So your staff went to this meeting and didn't tell you what happened? Is that right?
That's right.
Really? Okay. And the project narrative indicates that there is going to be, could you scroll down a little bit for me? Down a bit more, please. It indicates site improvements that are going to be done and a traffic light at the entry drive. Did you know that? That they're proposing a traffic light?
I've not seen that.
Okay, okay. And when you did the DNS that you did you consider the cumulative impact of all of the comp plan changes that were proposed?
I did.
And tell me how you did that.
So I looked at and I considered, for me, a cumulative impact of a rezone redesignation would lead to additional rezones or redesignations. So in other words, if you, let's hypothetically say that you decided to rezone an area like central Issaquah in a more intense zoning district and land use, it could then lead to additional changes in zoning around it. And as I looked at this site and the land uses that were surrounding it, that was the cumulative impact that I looked at in terms of the proposed legislative action that was being considered.
Doesn't SEPA say you look at all the cumulative impacts of all of the proposals that are before the city at one time?
Yes. Did I not answer that correctly? I don't understand.
I think you indicated that you were concerned with the impacts that might occur about induced zoning changes.
So
that's what I heard you say.
So for each land use change, there was a consideration of how that specific land use change would affect adjoining properties. So that was part of the cumulative analysis that I went through when I was considering the cumulative impact. Obviously, the cumulative impact of all of the proposed zone changes and redesignations that's part of this annual docket was considered as well.
Okay. Ms. Nevin, you've indicated you've had a lot of experience here in the city. The program that the district is talking about is a 215,000 square foot high school designed to serve 1,400 students. Can you do a traffic analysis of the number of trips that are generated by that activity?
I can't. I'm not a traffic engineer.
Could you ask, excuse me, I don't mean to interrupt you, go ahead.
Sorry. So the way that this typically works, bless you, the way that this typically works is when a project level application comes in.
No, that's not the question. My question was, could you, with assistance from other people, determine what the trip generation impact on traffic would be from a 215,000 square foot high school with 1,400 students? Is that possible?
No.
No?
No.
And why is that?
Because there's other factors that are involved. For example, how many access points are out onto the street.
There's only one here.
I don't know that.
That's what it says.
Well, but you're reading something that they prepared. It's not part of any permit applications that are in review at the city at this time. So I own nothing up there. It could say that it's going to be an orange high school. Fine, it's going to be orange. I mean, you're asking me to validate something that they've got, and I'm not going to do that because it's not gone through a process yet.
You know what the ITE manual is?
I do.
What is it?
Institute of Traffic Engineers, they basically generate traffic volumes based on a survey of land uses that they've done.
And in the ITE manual, is there trip generation for high schools?
There probably is.
Did you look at it?
No, I did not.
We are at 13 minutes, so another 3 questions.
I'm going to pick the best 3. Did you do any noise analysis for the stadium?
How could I? Don't know where the stadium is. I don't know what the configuration of the stadium is. I don't know what the surrounding building massing will be around the stadium. I could not do that without knowing those details.
And did you ask the district to supply you with what their best and current site plan is so you could figure that out?
No, I did not.
Did you talk to the school district at all?
I did not.
Not a word?
I did not. Other than the email that came to me requesting that this be included in this docket, which wasn't a conversation. It was an email that I forwarded to Ms. Heinonen. No, I did not.
One more.
Did you look at the whether or not the adjacent intersections near this high school were close to failing levels of service?
I did not.
Okay.
Thank you. Ms. Skelton, cross-examination.
Thank you. Mr. Niven, Mr. Aramburu was asking you whether you spoke to the school district about any potential plans the district had for development of the Providence Heights site, and you indicated you did not. Why was that?
Okay, let's break this up into pieces. So there was, like I said, there was a time before they met with our staff in a collaboration meeting where I did sit down with their facilities director, Mr. Steve Crawford, and Mr. Tom Mullins to talk about this site. At that time, the school district didn't own the site. There was pending litigation on the demolition permit, and the conversation was really more academic, like, hey, we think we can fit all this stuff here, or we might be able to, just, what do you think? Then time passed, and the school district acquired the site. They then asked to formally meet with my staff as a part of a feasibility meeting, where some of the bigger items could just be discussed, which would help them refine their designs, so that then they would, when they come in for a pre-application meeting, we could have a more informed conversation about what needs to change about the site plan to be able to get it through the permitting system.
So in your capacity as the SEPA responsible official, why did you not ask the district for more information about any proposed project at the site, as Mr. Rambrew was suggesting you should have done?
I did not, because I didn't think it was warranted. I believe that this site plan that has been shown, the earlier version that I saw, there are a lot of different code requirements that are going to need to be worked through. It generally takes my staff 4 to 5 months to get through a permit review on a site of this size, and to try and do that in a 20-minute conversation. So what I did was I considered all the comments that came in. I considered what I think the Providence Point neighborhood would like to see happen here, and it did not seem appropriate for me to ask the school district to provide more technical information on a site plan that was probably not going to be the one that would ultimately be moved forward to the city council.
I believe you described your meeting, or your staff's meeting with the district, as a pre-application meeting. Is that correct?
We call them collaboration meetings. Generally, they're pretty high level. There might be a site plan, there might not be a site plan. It's really to talk about kind of the bigger picture items on the property.
Would it be typical for the city to put materials submitted for that type of collaboration meeting on the city's website as a project?
So, typical's an interesting word. So what we try to do is we're trying to be as transparent as we can be with our neighbors and our residents. And so when a project comes in, we try to gauge whether we think it's likely a real project or somebody just, speculating on a piece of property. And generally, then it gets the green light to get put on the city's active projects map. So that's how I think Providence Point learned about this potential application, was that there was this site plan that was put on the city's webpage. In some ways, I would say that could lead to people being concerned about something that may not really happen. But I think we're erring on the side of transparency here, where we'd rather have a conversation with our neighbors than not. So,
thank you. I don't have any further questions.
Mr. Haney, redirect.
Madam Clerk, could you put up Exhibit P5? Now, Mr. Niven, Mr. Rambrew asked you about this exhibit, and if I can ask the clerk to scroll down a bit towards the bottom, right there is fine. Mr. Niven, in the blue area underneath the orange rectangle, there's a statement about how big the high school is going to be. What does that statement say?
It says a fourth comprehensive high school for 1,600 students in grades 9 through 12 will be built to reduce student populations at Issaquah and Skyline high schools and meet the district's needs into the future.
And in the second paragraph below that, there is a statement as to what the size of the building will be. See that?
I do.
And what is that size?
It says the new 240,000 square foot building includes blah, blah, blah.
And Madam Clerk, would you put up Exhibit P4.4, which Mr. Aramburu asked Mr. Niven about? And if you'd scroll down, please, in that.
Thanks, Tina.
A little bit further. Okay, where it says program, Mr. Niven, what's the size of the building that's listed there?
It's there, it says it's 215,000 square feet.
Not 240,000 square feet?
No.
And when it says what the size of the high school is going to accommodate, how many students does it say?
This one says 1,400 students.
Not the 1,600 students that was in the other document?
No.
Mr. Niven, could, at the time that the school district actually submits a site plan for this proposal, will you have a better idea as to how many students the high school will have?
So when they submit for a formal pre-application with the city, assuming they're going to do that, that's an optional process as well, there is a project narrative which then staff will use to better understand the plan set that comes in for the pre-app.
And the plan set that comes in for the pre-app could be for a high school that's less than 215,000 square feet, couldn't it?
Absolutely.
Or it could be more than 240,000 square feet, couldn't it?
Absolutely. It's whatever they think they need.
And it could be for more than 1,600 students, or it could be for less than 1,400 students, correct?
Right.
Isn't doing an analysis at this point kind of analyzing a moving target unless you have a site plan?
I do want to object again to the leading nature. I mean, is it a moving target? I mean, what a question.
Well, I think, Mr. Aramburu, you've shown it's a moving target. Let me rephrase the question, though, Mr. Niven. Mr. Niven, at the time that site plan, why would an analysis of the number of students and the size of the building at this time not be productive from an environmental standpoint, if you believe it would not be productive?
Because my guess is those things have not set yet. So the size of the school and the number of students, those things are all worked through between district operations and their consultants that are preparing their plans. So until those things stop moving or bouncing or evolving, doing your technical analysis doesn't make sense.
Okay, Mr. Niven, now I'd like to ask you to look at Exhibit C10, and if you can put that up, Madam Clerk. And if you would scroll down a little bit, please. Mr. Niven, I see that there is a section.
I'm going to stop you, Mr. Haney. I'm not sure on redirect you're able to ask about evidence that wasn't discussed earlier in the testimony.
Actually, I'm doing this in response to Ms. Goodman's question during the, before Mr. Aramburu began his cross-examination, and also in response to Mr. Aramburu's questioning regarding compatibility, and that it was based solely on the code. Because this analysis on this exhibit speaks directly to that.
I'm going to phone a friend.
Well, since it's your own objection you've raised.
I'm asking on this explanation that I've just been given, because I'm not a legal person.
Yeah, if he's using it to rebut an earlier question either of opposing counsel or legal counsel, then you might go ahead and allow that.
All right, well, I'll allow it. Thank you.
Thank you, Council President. Mr. Niven, there is a discussion in this under comments and evaluation that talks about compatibility and the issues you analyze. Can you walk us through that in response to what Mr. Aramburu asked you about compatibility and what Ms. Goodman asked you about compatibility?
So, well, I think we've talked about this a bit. So the community facility zone, as I state in the final DNS, is envisioned to be a designation that is compatible with surrounding zones. If you actually look at the land uses, we allow high schools in single-family zones. We just don't allow them in single-family small lot. So it's really hard to construct a non-compatibility premise when we allow high schools in single-family estates and single-family, I forget which the other one is, maybe duplex. And so I think, so part of this is, thinking about how this proposed land use change and redesignation will impact kind of the surrounding areas and the rest of the city. And so that's kind of what I went through with this.
And you also testified in response to Mr. Arambru's questions that you considered comments in making your environmental determination. Is there a discussion of that in this part of the checklist?
So the decision, so under potential mitigation measures, what I wrote was the city believes the issue-specific concerns raised during the comment period relating to non-project actions can be fully mitigated during the permitting process for any future schools. Project-level SEPA review should consider the incorporation of mitigation measures addressing potential adverse impacts on traffic, noise, lighting, and the loss of mature vegetation. So what I was trying to do with this was actually give a very clear roadmap to both the school district doing the project-level SEPA review and to my permitting staff when projects come in on this property, what they should be thinking about. The SEPA process includes a comment period to allow just for this, to allow for people to engage and to tell the city what they're concerned about. And so what I was trying to do here was really say to both the school district staff and to my staff that these are the things you need to pay particularly attention to. And there will be a neighborhood meeting with, or community conference with this project if it ever makes it, before it ever gets to the Development Commission. And the whole idea is to allow for another public engagement opportunity to talk about things and try and work those issues into the site plan to minimize their impacts. This process has a lot of opportunities to try and kind of bend it in a way that will be a lot better than I think what the Providence Point folks saw on the city's webpage.
Mr. Haney, I'm going to stop you for a moment. I'm going to ask my fellow council members. Redirect is not generally supposed to be this involved, and our original sort of timeline for developing this was to have both cross and redirect be pretty quick. We're 10 minutes in now on redirect, and I'm going to ask my fellow council member if it's okay to say we want to stop at this point on the redirect.
I think that we have to make sure that we're fair so that the same amount of time is afforded to councils, whatever decision we make. I think if we cut it off now and Mr. Haney has had an extra certain amount of time, then we need to allow that time for others as well, to be fair.
Noted. All right, I see agreement. So I will, however, ask if council has any further questions for this witness before they're excused. Councilmember Goodman.
I do, thanks. Mr. Niven, Keith, you were reading from something just now. Where were you reading?
I was reading from the final DNS, which I don't know what exhibit number that is.
Is it C10? It is up on there.
Where were you reading on C10?
If you go down to the bottom of the first page, council member, whoops, stop. Potential project mitigation measures.
Okay, great.
And it
And that's the
continues.
one that you were talking about, that you were sort of sending the message to the city staff and the school district staff?
Absolutely.
Thank you.
Any other questions for this witness? You are excused. And with that, we will move to the school district's direct on their witness.
The district calls Jacob Cooper.
Mr. Haney, would you do the honors?
Oh, yes, sorry. Mr. Cooper, would you please raise your right hand? Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Cooper, please state your name and title for the record.
Jacob Cooper, I'm the Chief of Finance and Operations for Issaquah School District.
And how long have you held that role?
I've been in the school district since 2004 and had this role since 2006.
And what was your position prior to being Chief of Finance and
I
Operations?
was the Director of Finance for 2 years.
And what are your responsibilities as Director of Finance and Operations?
Currently, I have a responsibility of overseeing basically anything our system is divided into two. So we have a deputy over the academic side, and I have all the operational side. So that would include capital projects, maintenance, finance, student records, technology, risk management. I think that's probably it. Transportation, sorry about transportation, and food service.
So you mentioned capital projects. Do you have responsibility to oversee potential construction of new schools?
I do.
And what is your role in that area?
My role, first off, begins with the initial planning of projects, from all the way from the creation of a bond package that goes before the Citizens Committee, which we usually run, then the Board of Directors, so the cost estimates and feasibility, and then also examining the feasibility of school sites on the real estate acquisition side, cost, and then timelines for construction, and then constructability as well.
Are you familiar with the property that's at issue in this appeal? And for our sake, I'll refer to it as the 3 contiguous tax parcels off of 228th Avenue Southeast, which is the Providence Heights property.
I am.
And what has your role been with respect to this property?
I have been involved with this property since a letter sent to the owners in September of 2014. After that, the district has then proceeded to pass a bond issue where I was also working with legal counsel and the board of directors for an eminent domain action in July of 16, and then involved in the litigation as an interested party for the historical landmark status, and then, of course, high-level layout and design of the site as well.
And are you familiar with the physical characteristics of the property?
I am.
And are you familiar with the current zoning of the property?
I am.
Do you know what that zoning is?
Single-family small lot.
So you mentioned that you first sent a letter about the property in 2014. How did you become aware of the property at that time?
It was marketed by a real estate brokerage.
And was the district interested in the property as a potential site for schools?
Yes, we were so interested, in fact, that we put a letter of interest in before we actually had bond proceeds to proceed. So we believe the site, given its equidistant location between Issaquah High and Skyline, was very appropriate for a school site.
And was the fact that the property was being marketed also something that prompted you to inquire about it?
Yes, a willing seller, of course, is a preferred way to acquire property versus eminent domain, which can be both politically difficult and economically and legally challenging as well.
And did you believe at the time the property could be suitable for your school purposes?
Yes.
And why was that?
The site had, it's about 40 acres in gross, and it has a significant amount which is developable, because one issue we have had with our exhaustive property search was the amount of developable property within the parcel itself. We believe that utilizing the 40 acres to its full potential, because property is at a premium, close to or at $1 million an acre on the average, sometimes $1.5 million, that this site would be able to fit a comprehensive high school and an elementary.
And at some point, did the district make the decision to seek to acquire the property?
We did.
And when was that?
We sought to acquire the property in July of 2016.
And by what means did you do that?
Eminent domain.
And what is the current status of that eminent domain action?
The district currently has possession and use of the property.
And do you know what that means from a practical perspective? What is possession and use?
The district can design, build, and operate and open a school on the site.
You mentioned that you're familiar with the current zoning of the property. What is your understanding of what is permitted under the current zoning?
My understanding is that, as was mentioned earlier in testimony, an elementary school, a middle school, a junior high school, and all the accompanying play fields or infrastructure needed would be able to be sited on the site, given its current zoning.
Does the district currently have elementary schools or middle schools with play fields?
All of our school sites have play fields and or lit fields or artificial turf, excluding Gibson Neck High School, which is a magnet school and has no outdoor athletic facilities.
And can any of those play fields be used by the general public?
All of them, a lot.
And you mentioned lit fields. What do you mean by that?
Our comprehensive high schools, which are Liberty High School to the south, Issaquah High School in the corridor, Skyline High School on the plateau, all have stadiums as they were reflected in the city code and are lit for use in the evening time. Our middle schools currently, Issaquah Middle School, Pine Lake Middle School, and Maywood Middle School are also lit facilities that have bleachers as well. So all our middle schools have bleachers and lights currently, except we have not yet funded Pacific Cascade Middle School or Beaver Lake Middle School for the additional lights.
Are there any locations in the school district boundaries where schools are located next to residential zones?
All of them.
And you heard prior testimony tonight, but did the district suggest that the city consider redesignating and rezoning the Providence Heights property in this, that's at issue in this appeal?
Yes.
And what did the district suggest that the property should be rezoned and redesignated as?
CFF pursuant to the city's code.
So you indicated pursuant to the city's code. Why? What do you mean by that?
The city's code, which was recently changed in the December of 2017, allowed or created a CFF designation for the goal, the policy goal to have clear parameters for which the school district can design and or site schools upon. Additionally, there was also a desire to limit or curtail administrative adjustments to the process, particularly height or pervious or impervious surface, which often we have to get well into the development process before those issues are cleared up. So this was a goal for clarity and a recognition of our inability to site schools outside of the urban growth area.
Is the CFF designation also used when property comes into public ownership?
It is, including the city or county government as well, is my understanding.
And do you know whether that's what prompted the request from the school district to the city to consider the CFF designation here?
Yes, that is the case.
Okay. So you mentioned that you're familiar with the process that the city undertook in 2017 to amend its code and design standards related to the CF designation in the CFF zone. Is that right?
It is correct, yes.
Okay. Can we put Exhibit S-3 up, please? Are you familiar with the ordinance by which the city adopted those amendments?
I am.
And is that the ordinance that we're looking at here, ordinance number 2806?
Yes, it is.
And was it your understanding that one of the purposes of these amendments was to facilitate the more efficient siting of schools as the city densifies?
Yeah, that is correct, and to also align with the goals of the GPM or GMPC or the King County Policy Planning.
And do you know whether SEPA
I'm sorry, I got a question from one of my fellow council
I have a
members.
question about whether he's able to testify to about what the purposes of adopting an ordinance is, and it was the city council that adopted it. I'm not sure. So the questions are about the purposes of adopting it, and well, I think it's, as long as it's clear that it's his opinion, I think that would be one thing, but he's not city staff and he's not on the city council, so I'm not sure it's appropriate that he testifies to the, as to the purpose or the goals of an ordinance.
Fellow council members, there's a general consensus that that's not, that we don't think that's an appropriate question.
So may I address the objection? It's just, this is an ordinance that relates to siting of schools, so I've established that Mr. Cooper is familiar with its provisions.
Being familiar with the provisions is not the same thing as understanding the intent. The intent would
Sure.
be the council members who passed the ordinance.
Sure.
I guess my
If you could
intent
move
was
on to
taken-
your next
my
question,
intent
that'd
was
be
taken
great.
from the
If you
public
could
record.
move on to your next question, that'd be great.
Sure. Do you know whether SEPA review was completed as part of this amendment process?
It was.
And do you know whether there was a determination of non-significance related to these amendments?
There was.
So you've indicated that the district plans to construct a high school and elementary school on the Providence Heights property, is that right?
Yes.
Can you describe the district's process for planning and completing that project?
Well, historically, and it takes up to 24 months just for the planning and design of a facility that comprehensive and large. We have gone through 50-plus iterations of design on the site itself, most of which, and that's was interesting when you showed the difference of our website and what was on the city's project narrative, because just recently I sat down with a team and cut classrooms out for budgetary purposes, and so the plan is ever evolving. So oftentimes, first step is take a look at the site, make sure soils and water, so early feasibility on soils and water to make sure, of course, there's no landslide risk, and that, what's the hydrology doing on the site, what do soils look like, can we actually site a school there? That'd be check one, and then onto that, it's more onto the design phase of the building. We look at, as Mr. Niven testified, examples of how we may construct the facility, the orientation of elements on the site, what may facilitate student access, ADA compliance. So they're ever evolving. I do not have day-to-day meetings with the architects. They bring me in about once a week, once every couple weeks, to take a look at their progress and figure out where they're at. So right now we are in conceptual design.
Has the district entered into a construction contract with any architect or any contractor related to construction of the proposed schools?
No.
And you've heard some testimony tonight about a meeting that occurred between the city and the district in June of 2019. Were you aware that meeting occurred?
No.
You were not aware that that meeting occurred in June of 2019?
I knew that my staff was going to have a feasibility conversation with the city. I was unaware of the drawings were going to be made public at that point in time, given that we were having a staff-to-staff conversation. And it was a pre-application meeting.
Ms. Skelton, we're 13 minutes in. If you could come up with 3 more questions, that'd be great.
Have you reviewed the documents that are available on the city's website, which are, I believe, Exhibit P4?
I have.
And are those the project plans for the schools that the district intends to construct on the Providence Heights site?
They are not.
Are you familiar with the site plan that's currently posted on the district's website?
I have, and it was early on in the process.
And does that site plan reflect the plans that the district intends to use to construct schools at the Providence Heights site?
It does not.
How many different versions of conceptual plans has the district developed to date?
50 plus.
And we're going to stop there. Before we move on to Cross, I'm going to ask if any of my fellow council members have questions of this witness thus far. Councilmember Goodman.
Feels weird calling you Mr. Cooper, but I guess I should call you Mr. Cooper. So what's there's been mention of 1,400 students, 1,600 students. Is it fair to say that the high school would have more than 1,000 students when it opens?
Yes.
And what would be a fair range? Say that a number of students.
Between 12 and 1,600.
Okay, thank you.
Any other questions? Councilmember Walsh.
Not a question, but Tisha, the clock is not running, so that would be helpful for everyone involved.
Can I ask a question? Is it not working? It's flashing.
The chair, the council president, has been managing the time manually, as am I, and so
Okay.
starting and stopping the timer whenever there was a question at the dais was proving to not feel terribly efficient. So we're both tracking time here. If it's helpful to have the time displayed, I'm happy to accommodate that.
Okay. I would ask that when we start into a direct or the appellant's cross direct hybrid, that we give 13 minutes, which is where I've been pulling the hook. Councilmember DiMichele.
I'm wondering if the conceptual plan on the website, is it clearly labeled as a conceptual plan on the website?
Yes.
Okay.
It says concept design.
Concept design.
Councilmember Ray.
Thanks. This is a bit of a follow-up to my earlier question about what compact design is. As I look through Exhibit S3, there's a lot of references to urban schools. What's an urban school?
Well, that is a very good question, Councilmember. I think that both parties, the district and the council, have worked towards a definition of urban schools. We also use the term compact schools in the code as well. So whatever your code is at the time, currently it's CFF, which in my mind, as we designed the code, that means a site that has very small or narrow setbacks, height of 65 foot, impervious and pervious ratio of 90:10, et cetera. So that's a more intensive use of acreage and a more vertical than horizontal school than you would see traditionally. That's how my staff uses it when we're designing.
Okay, thanks.
Any other questions? With that, Mr. Aramburu, it is your witness.
If you would put up exhibit P 4.3, please. Now, this is a overall site and circulation plan that was prepared for this property, is that correct?
Yes, it was a site plan used to communicate with staff in our pre-application process on the 21st of June is what it's dated as.
And this isn't labeled as a conceptual plan, is it?
No, but again, that was not published by the school district.
Pardon me?
That was not published by the school district on the website. We would have watermarked it as such. That was on the city's website.
Well, would you scroll down a bit for me? On the drawing? And just over to the right a little bit? So this was prepared by Skanska. Who's that?
That is a firm that we have a pre-construction services contract for.
And Bassetti?
Our current architect.
And Issaquah School District, that's you, isn't it?
That is on the footer, yes.
Okay. So take responsibility for this drawing, correct?
I take responsibility that it was used in a staff-to-staff meeting.
Okay, if you could scroll up a little bit for me. Now, you've said there's been 50 iterations of different site plans for the property. I guess what I want to ask is some generalities here. The site plan here shows some baseball fields and softball fields in the north side of the property. Is that pretty much something that's lasted through these 50 iterations?
No.
Okay. What's the current iteration?
I think the most current iteration I have seen is that those fields are moved to the right. Sorry, I don't know which way we're looking at. Was that northeast?
Well, to the right would be
yes,
east.
To the northeast then. And depending upon the iteration at any given point in time, and also the height of the retaining walls that we are working on, those fields have been condensed, moved, flipped. I've had baseball on one side, softball on the other, batting cages, no batting cages, et cetera.
Okay. I just want to get to generalities here on the property. Fields moved around a little bit in the north end, correct? And then on the, where the point is, over there, the drawing shows that's the location of the elementary school.
Correct, yes.
And is that still, as we go through these iterations, the current iteration, still have the elementary school over in that point?
I believe so.
Okay. And we've got a, right in the middle of this, unmistakable football field. Is that still pretty much generally where the football field is in these multiple iterations?
Yes and no. We have had iterations where the field is on the 228th side. We've had iterations where the field has been flopped with the high school. We've had iterations where we've turned the parking and the field because it's also dependent upon how much structured parking we decide to do or not to do on the site and whether we exceed city code or not. So there is no generalities on the location of the field.
What's the current plan? What's the current plan? Doesn't the current plan have that field just kind of right in the middle there between the tennis courts and the parking?
The only current plan I can comment on are the ones that are publicly disclosed.
This one?
No, this one, here.
Okay. And so there's a...
Or the one published on the district website.
Okay.
Everything else is
So let's scroll down a little bit to the south here, if you would for me, please. So the high school is kind of in the south part of the property. These iterations, the most current iteration, still have the high school in the south part of the property?
I believe so.
Okay. So generally what we're seeing here, give or take maybe 30, 50 feet, whatever it is pretty much what the plan is.
No.
Would you agree with that?
I would not agree with that. I just told you there were several iterations we've gone through that don't reflect
I
this
understand.
layout.
I'm talking about the current iteration. Where are we right now?
That is the most current plan publicly available.
Okay, good. What's the minimum size of high school that's acceptable on this property? As far as the district is concerned to meet your needs, how many students?
Currently, we believe on our communication to the voters and our bond process was a school of approximately 1,400.
Okay, so that's what the district needs to meet its educational responsibilities. Is that correct?
We would like to have that many students to alleviate overcrowding in our two largest comprehensive high schools that are located nearby.
Okay, but maybe you build something a little bigger.
Currently, we do not have the budget to build anything bigger.
Okay.
Mr. Aramburu, I want to point out, I think I made an error earlier. I said that this witness, you were doing both a direct and a cross. You know, as I realized the pre-hearing documents we came up with, Mr. Cooper was not one of your witnesses, so this is just cross, not direct.
That's correct, yes. Now, Mr. Niven was here, and he testified about the process he went through. Did you ever reach out to Mr. Niven or other staff to tell them what you were going to do on this property?
I'm going to object to the questioning as being outside the scope of the direct examination.
I'm sorry, elaborate further.
So he would be limited to cross-examining him on issues that I covered in my direct examination.
There was multiple discussions about the numbers of schools on this property.
Sorry, Councilmember Goodman?
I'm sorry, Ms. Kelton, was it you about the scope? So when you were asking questions, you asked about meetings.
I asked about the one feasibility meeting.
Okay. And I don't remember what Mr. Aramburu was just asking.
Sorry, Mr. Aramburu, what was the nature of your question again?
Let's go on to a different question.
All right, thank you.
In the, there was a project narrative that was written for purposes of the pre-application conference. Do you remember that?
Yes, I saw it this evening in the evidence.
And did you have any part in preparing that?
No.
Do you know who did?
No.
Is it fair to say, in terms of the drawings here, that the high school and the elementary school will be in separate buildings?
Yes. That's our current iteration.
Okay. Let me, if you would bring up, let's see, Exhibit P 4.5. The first drawing there shows the former development on the property, doesn't it?
That appears to be the chapel and the buildings. I would say, I believe so.
Okay. And those buildings have been demolished now. They're no longer there.
Yeah, that is correct.
Okay, thank you. And if you'd scroll down to the next drawing, please. Let's go one more. Well, two more. Okay. And this is a drawing that, again, Scansa, Bassetti, Issaquah School District. Does this drawing show the kind of the general layout of uses on the property?
Again, I've already answered the question, but yes, in the June meeting, I believe that was the current iteration.
Okay. And is it the proposal of the school district to maintain these forested buffers around the site that's shown here?
The buffers, of course, will ultimately be decided as we move through the project itself. So depending upon the zoning designated on the property and construction, the resulting buffers, of course, would be looked at during the district SEPA process.
But I mean, can the district commit to buffers generally of this size?
I'm unable to provide you that commitment here this evening, given that the project hasn't even been allowed for zoning, and secondarily, I don't even know the distances of that drawing.
Mr. Aramburu, in the spirit of generally trying to keep to a half hour per witness, I did limit Mr. Haney to 10 minutes on redirects, and you're at 10 minutes, so I'm going to ask for just a couple more questions.
Does the district have a design-build contract for this facility?
The district has pre-construction services, not a construction contract, which means the general contractor and the architect are working with us on the design of the project. We have not executed construction documents yet, for obvious reasons.
Well, I'm not going to go to the trouble of pulling up the drawing. The Issaquah School District bond projects page says Issaquah School District has been approved by the Capital Projects Advisory Review Board to use progressive design build on this project.
Correct. That is a method of procurement for this project.
Okay.
Right.
That's all the questions I have.
Thank you. And it is, I now ask the school district if they wish to redirect. I'm sorry.
Mr. Haney.
Sorry, Mr. Haney. Cross-examine.
Thank you. I just have, I think, just a few questions, Mr. Cooper. And if we could, let's see, if we could look again at Exhibit P 4.3. Let me, as long as we, well, okay, I'm sorry. Okay. So, Mr. Cooper, this site plan you said was the most current one that was publicly available, correct?
Yes.
And did I also understand you to say that there had been 50-plus iterations since this site plan, or is this one of the, were there some before and some after?
There are some before and some after. There's not been 50 since this June iteration.
Do you anticipate anticipate more iterations of the site plan before you actually submit something to the city to review?
Yes, absolutely.
Do you have any idea how many iterations you might continue to do?
Not really. I mean, we had several in the last couple of weeks.
And could those iterations change the location of some of these facilities, for example, the stadium?
They could, yes.
You mentioned that the stadium had been changed, or the location of it had been changed several times during previous iterations.
Yes.
Is that correct?
Yes.
And so that could change with future iterations?
It could.
Did I also understand you to testify that you've actually made the high school smaller in some ways since this drawing?
Yes, and I believe the elementary school is smaller as well.
And can you give us an idea of the magnitude of those changes?
Roughly 200 students will be looking at 6 to 8 classrooms on the high school, a difference of, and then we downsized the elementary from 20, historically like to build 32, we're down to 24 on the site, so 8 classrooms there. So you're looking at, between the two buildings, you're looking at 16 classrooms of reduction.
So is it fair to say that the design of the site remains somewhat fluid at this time?
Absolutely.
And can I get you to put up, it's 4.2, and the part of it that Mr. Rambrew was asking about just at the end, I believe that's a few slides in. Okay, this is the one. Can you explain what the stadium facility is there? I can't tell, does it have elevated stands next to it? Or is that a stadium facility that just has bleachers?
I can't quite tell from that drawing. I don't believe I see covered stands on that iteration.
Are covered stands an option for this stadium, or is that something that absolutely must be there?
The district has covered home side stands in all of its other 3 stadiums, and so during the bond planning process, we did make a political promise to our constituents that we would have parity in when it came to facilities.
Those designs are still in flux?
They are.
And I also noticed that the elementary school, so if those are elevated stands, they would be between the stadium or the athletic fields and the single-family properties to the, is that the north? I'm sorry, I'm mixed up.
West.
The west.
Yes. I believe in most of our iterations, except for the very early ones, the stadium or sports field is not located, it's mid-site. It's in the middle of the site surrounded by other facilities.
So there aren't any plans to place it next to the single-family residence?
There are no plans to place it adjacent.
I don't think I have any further questions.
Thank you, Mr. Haney. And now, redirect to Ms. Skelton.
Thank you. Could you please put Exhibit 4.3 up again? 4.3? Yes, thank you. If you could scroll down to the right-hand corner and make it just a little bigger. Mr. Rambrew was asking you whether the document was labeled as conceptual. Do you recall that?
Yes.
Do you see what's written vertically there in the corner of that document?
Oh, yes, pre-application meeting submittal.
Is it your understanding that this is a conceptual plan for the district site?
It is.
What kinds of decisions does the district have yet to make before it can settle on final designs?
There are many, council, including location of the proposed schools on the site itself, exit and entrance, the amount of traffic queuing, traffic mitigation, boundaries, which also have a huge impact on the traffic itself.
When you say boundaries, do you mean service areas?
Service areas of the buildings, yes.
How about classrooms? Have you decided number of classrooms for the schools?
No, and we are facing, as I said, as time goes on, the budget, our buying power decreases, so we've had to downsize our number of classrooms.
So at this point, does the district have final plans that would be available to be submitted to the city for review?
No.
I don't have any further questions.
Thank you. And I will ask if my fellow council members have any questions for this witness. Councilmember Goodman.
No. I want to follow up on some questions about the conceptual plans. So you testified that the plans aren't final and they're evolving. There have been 50 iterations. So I want to ask you about some of the concept elements themselves, because there's been talk about movement around the site. But from my understanding, there are certain elements that are not going to change. So one of them would be the plan would be there's a high school. True?
Correct.
An elementary school.
Correct.
A stadium that would have a football field, track.
Yes.
Lights. You talked about the parity. So
Yes.
the assumption is there'd be lights.
Yes.
Seats, covered seats probably. Again, the parity.
Yep.
Other sports fields.
No, unlike our other schools, no other practice field except baseball, and our other two comprehensive high schools also have practice fields in addition to the main stadium, which would not be the case on this conceptual design.
So were there other sports fields?
Those are baseball and softball.
That's what I meant. Sports. Yes. So there would be those sports fields, correct?
Correct.
Baseball and soccer. Parking?
We will have to have parking, yes.
Tennis courts?
Tennis courts, the number has been in flux.
But tennis courts?
Yes, potentially tennis courts.
Okay. Portables?
Yet to be determined.
Yes, portables, probably. So all the schools that I understand open with portables. Is there a place to put portables on the site?
Again, we haven't finalized, and what we often do when we're planning these schools is we will try to find a place where we could stub in or pre-plan potential portable classrooms. Again, we are not to a place where we've decided on where, the number, et cetera.
Okay, and so, and you testified earlier that the plan, generally speaking, would be about 1,400 students.
Yeah,
Could that, sorry, go ahead.
Which is consistent with our bond planning in 2015 and following campaign in 16, yes.
Okay, so could it be that there would be more students on there if there were portables on the site?
Hard for me to say because we haven't drawn the boundaries yet, or I haven't anticipated. I have projected potential enrollment, but that is a long way down the road because it will depend upon long-term land use decisions made by the cities and county.
Okay, but generally the elements that we just talked about, regardless of the number of iterations, those elements on the site would be there?
Yes.
Some area in that site?
Yes,
Okay.
more likely than not, yes.
Okay, thanks.
Any other questions for this witness? All right. Thank you very much.
Thank
You're
you.
excused. Now, I don't know exactly the way to say it, but what I have next in my order of proceeding is rebuttal testimony by appellates, witnesses, if any.
There'd be a question as to whether or not at this point in time, the appellants wish to call any witnesses in rebuttal.
Do the appellant wish to call any witnesses in rebuttal?
I'm having so much fun here, I've lost track of time. We were trying to get this over in a certain period of time. How
Well,
much time do we have left?
here's what's going to happen on time. So we started at 8:14. What I've agreed to with my fellow council members is that at 11:14 or thereabouts, I'm going to ask them what their appetite is. If we're still in this hearing, I'm going to ask them as to their appetite for further for continuing the hearing this evening or continuing it to a later point. And that was the agreement that I had with my council, because there's a concern whether we're going to be sharp enough if we get late enough in the evening to be of good service.
The parties are aware that I am not available from tomorrow until the 15th.
We made it very clear that 3 hours was, we were going to look at it at 3 hours.
Okay.
And if everybody's having fun, then we can keep going. But if not, we had a substantive discussion about the exact amount of time, and 3 hours was the point that I got asked to ask my fellow council members.
So with that understanding, I do have a rebuttal witness who's seated next to me. We're going to try to expedite his testimony. And go up there.
So just for our planning purposes, the district does have a rebuttal witness also, so if we can share the remaining time, that would be our preference.
Well, I look to my fellow council members. Councilmember Ray.
I'd like to see both the rebuttal witnesses this evening at a minimum.
Yes, me too.
I'm seeing at least grudging acceptance of that concept, so we will make sure to hear from both of these rebuttal witnesses this evening.
Thank you.
And then do a time check with my fellow council members. We will be, I think, generally using the same time constraints that, as an upper limit on this process.
Prepared to swear the witness in if we're ready.
Thank you.
Mr. Weckner, would you please raise your right hand? Do you solemnly swear that the testimony you're about to give in these proceedings will be the truth, the whole truth, and nothing but the truth?
As I know it, yes.
Mr. Weckner, would you please
I'm sorry, can you stop for a second? Is that a standard response to swearing in? I've not heard it said that way, as I know it. Is that acceptable?
The truth as I know it, yes.
Yeah, I'm just wondering if that is a legally appropriate response to that question. I'm asking my counsel. I've never heard that response to being sworn in.
I have not either. If it's preferred, you could ask if he can simply affirm with yes, if he's comfortable doing that.
Can we please redo that? And
I'll
just
amend my
affirm with
response, yes.
All right, please proceed.
Would you state your full name and residence address, please?
My name is Dave Weckner. I do business as Weckner Consulting, and my address is 502 Northeast 6th Street in Coopeville, Washington, 98239.
And what is your profession, Mr. Weckner?
I'm currently a land use consultant, but I've worked for government as a land use planner, community development director, and planning director for many years.
And please give your educational background.
I have a bachelor's degree in psychology and a master's degree in environmental studies.
And have you served as a public official in the planning area in any jurisdictions?
Yes, I've been a land use planner in both Clark County and Vancouver, Washington. I've been the planning director for City of Sherwood, Oregon, the planning director for Josephine County, Oregon, the community development director for Island County, Washington, and the interim community development director for Port Angeles, Washington.
And you provide planning services in each one of those jobs?
Yes.
Have you provided a report to the city regarding these proposals?
Yes, I did.
And was that report submitted to the Policy Planning Commission?
Yes, it was.
Have you served in any manner as a SEPA responsible official?
Yes, I have. I was the SEPA responsible official for Island County, and in my role as the interim community development director for Port Angeles, I was also the SEPA responsible official by proxy in Clark County. By proxy, I mean I was assigned that role by the community development director, who by title was the SEPA responsible official.
Do you have any experience planning for school sites or school site selection?
Yes.
And what would that be briefly again?
At the City of Sherwood, I was a member of the school facility siting task force and provided a feasibility study for that task force, looking at several sites around the city and at the city's urban growth boundary which is determined by Metro. We're controlled, we don't control our urban growth boundary ourselves in Sherwood, it's controlled by Metro. And in the course of that study, I looked at the feasibility of a school site for an elementary school and a middle school on various properties, and did both environmental and land use analysis of those properties.
And what do you understand to be the basics of the school district's proposal for this property?
A high school, an elementary school, serving approximately 2,000 students overall. Parking, a or a stadium which would accommodate football and track, other sports.
And were you here for the entirety of the testimony this evening?
Yes.
Based upon what you heard this evening and from your other review, and particularly the testimony of Mr. Cooper, can environmental review take place meaningful environmental review take place based upon the program and project narrative that's been advanced by the school district?
Yes, I believe it can. The elements have been laid out and confirmed by staff and the project narrative and by school district personnel.
And tell me the kinds of environmental review that could take place based upon what you've reviewed.
What I would look at, if say I were doing the environmental review, if that's the nature of your question.
Yes.
I would look at traffic generation, the existing level of services, any existing traffic studies in the area. I would look at any determination of concurrency from the city engineer. I would look at the degree of vegetation removal and any potential impacts to views, drainage, erosion, et cetera, any impacts of removing that vegetation. I'd look at conceptual site plans that show the elements that be allowed with the current zone and elements that would be allowed with the zone change subject to the SEPA. I would look at stormwater treatment facilities that exist that might address impervious surfaces on the site, because the site plan shows a fairly crowded site with a high school and an elementary school and the ball fields. There's no conceptual stormwater facility. I'd look at potential access for students, pedestrian access for students, excuse me. I'd look where the stormwater might be discharged, as I said, the existing high schools and stadiums that are in the town already, that are in Issaquah and adjacent jurisdictions. I'd look at those and see, did they have impacts that needed to be mitigated in the siting of those schools. I'd look at any basin studies, the capital facilities plan, especially for 43rd and 228th, and potential reconstruction or improvement that are in a capital facilities plan of that transportation facility. And I'd look at any existing lighting studies and potential environmental impacts that were identified in those.
And there's been much made by the district of the kind of plans in flux, for lack of a better term. Would the review you're talking about be dependent on having a precise site plan?
No, it wouldn't. If you know the basic elements of the site development that's proposed by the school district, both in their bond and in the conceptual site plan that was drafted and presented at the pre-app and on the city's website, that's the first plan that I looked at. That gives you enough to know what the potential environmental impacts might be and where to look at density and intensity. That's the primary goal of SEPA. And you usually look at information as early in the process as you can when you're doing a SEPA environmental review.
And would it be possible, based upon what you know, to give substantive answers to the questions that are presented in the environmental checklist?
Yes, I believe substantive answers could have been given.
And let me just ask about one element of review, and that has to do with traffic and trip generation. Ms. Cooper indicated that there's going to be approximately a 1,400 student high school here and approximately 600 student elementary school and a stadium. Based upon that information, could trip generation and impacts on adjacent streets be analyzed?
Yes.
And how would that be done?
Primarily, I'd look at the ITE manual, as was mentioned earlier, for trip generation. That also includes some information on AM and PM trips. There are existing traffic studies, I'm sure, in the city that show a level of service at some of the intersections that might be impacted from this site. Because it is a single access onto 228th and 43rd, where the traffic goes from there is fairly easy to predict.
And would it be possible to review the traffic impacts or the difference in traffic impacts from, say, a residential development on the property that would be permitted by the current zoning and the school's proposal?
Single-family residential has a number assigned per the number of potential units that would be allowed under the current zoning, and then looking at square footage, even a range of square footage for the proposed site improvements, you would look at the difference between the two.
And have you looked at the difference between trip generation for a single-family development on this property and the school's proposal?
I would defer to Mr. Tillman's report that was, because he's the transportation planner who submitted that as part of the planning public policy meeting.
Okay. Do you believe the answers in the checklist that were provided by city staff to be sufficient for SEPA purposes?
No.
Why?
For example, if I may, the cumulative impacts. The cumulative impacts are looking at all, when you're filling out a checklist, you're looking at the cumulative impacts of all the rezone and comprehensive plan amendments. Actually, on the back of the checklist, attachments list all the zones and how they're being changed. There's 11 parcels that are LDR that are going to become recreational facilities. There are 2 that are mixed use that will become facilities, and there's 1 retail commercial that will become facilities. So there's an impact there in the change of land use, what parcels are available for what uses. There's actually an impact to housing as a result of that.
And do you, excuse me.
So that is one example where I think the checklist was deficient.
Okay.
Also looking at citywide, what are the zones and what they allow rather than on sites, because we're actually talking about the rezone of particular properties.
Okay, no further questions.
All right, and with that, I would ask Mr. Haney if he wishes to cross-examine this witness.
You know, actually, Council President Martz, I think it may make more sense, since the district has a witness that's in direct rebuttal to this witness, if the district wants to do its cross-examination
I was going to offer them next, so if your answer is...
You can go ahead if you have questions.
Okay. Mr. Wagner, you do understand that the current zoning of single-family small lot allows elementary schools, correct?
Yes.
And so allowing an elementary school on this site is no change from the current situation, correct?
Correct.
And you also understand, Mr. Wagner, that the current zoning allows athletic fields that are open to the public, baseball fields, football fields, and soccer fields that are open to the public. Is that correct?
Fields that are open to the public, yes.
And the stadium is a field that will be open to the public, is it not?
I don't know whether that would be open to the public, but a stadium is otherwise defined in the code.
Isn't, Mr. Wagner, the testimony that you heard tonight from Mr. Cooper is that the stadium will be used by the public? Didn't you hear that?
I'm not sure that I did, but I'll take your word for it.
Is that is having a football field, a baseball fields and soccer fields on this site different from the current zoning, significantly different?
sure I understand your question. A grass field where play is allowed is different than a football stadium that seats the number of people that football stadiums generally seat in your city.
Is it your testimony, Mr. Wegner, that all that's allowed under the current zoning is a grass field?
It says play fields that are open to the public. I don't know if it's any more specific than
It says
that.
football fields, baseball fields, and soccer fields that are open to the public, does it not?
I'm not certain I can answer that definitively, no.
So you're not familiar with what the code currently allows relating to sports fields in an SL zone?
I'm not as familiar with the code as you are, yes.
Now, there was testimony earlier about the design changing with respect to the high school. You heard that testimony?
Yes.
And the high school ranges anywhere from 1,200 students to 1,600 students. Was that the testimony you heard?
Yes.
Does that make any difference in environmental analysis?
It may make some incremental difference depending upon the amount, the size of the facility and the amount of traffic generated, yes.
And isn't it also true that the testimony was that there was at one point a 240,000 square foot high school, and then there was a 215,000 square foot high school? Did you hear that testimony?
Yes, I did. I've also read the student estimates for the elementary school.
Well, I didn't ask you about that. I asked you about the size of the high school building.
Okay.
And did you also hear the testimony that, in fact, the high school is smaller now, that additional classrooms had been cut out of the high school?
I heard that for budgetary reasons, Mr. Cooper did state that, yes.
And wouldn't that make a difference as far as the traffic generation and analysis?
It probably would.
And if the site plans for the high school changed between what they are now and what they might be when a master site plan is submitted, that could change the environmental analysis as well, could it not?
Yes, it would. And additional environmental analysis would be required because the project as constructed will require additional SEPA review, yes.
And wouldn't it be fair to say, Mr. Wegner, that at the time that there is an actual site plan and you know the actual size and configuration of the buildings on this site and the number of students that the high school is going to have, that you'd be able to do a better environmental analysis at that point of the impacts of that facility than you can do now?
You would do a more refined analysis, yes.
No further questions. Thank you. Skelton?
Mr. Wagner, you testified you had experience with school siting in Sherwood.
Yes.
Is that in Oregon?
Yes.
So that siting wasn't subject to the Washington Growth Management Act, is that right?
Nor SEPA. The state of Oregon has land use goals that cover many of the same areas of the 16 items on the SEPA checklist.
That wasn't my question, right? Thank you. You testified.
And I completed that analysis.
Yeah. So you testified that there could be meaningful review on the district's project plans. Sorry, you're not hearing me.
I'm not.
Okay. You testified that there could be meaningful review on the district's project plans, is that right?
Yes.
And that presupposes that there are, of course, plans to review, correct?
Plans or elements of the project, yes.
So elements of the project, what do you mean by that?
Those described in the project narrative.
So either a narrative description of the project or project plans?
Yes.
Okay. And so, for example, vegetation removal analysis, that would require a statement of what trees would be removed, is that correct?
Yes.
Okay, and stormwater analysis, the same thing, it would require an analysis of the amount of surface area that's covered, is that right?
Surface area and analysis of existing stormwater facilities and their capacity.
And access would, of course, require an analysis of the number and locations of the access points. Is that correct?
Generally speaking, yes.
And lighting, of course, an analysis of lighting would require knowing details about how the lighting would be set up. Is that correct?
That's a more refined analysis than one would normally do, yes.
And with respect to trip generation and traffic impacts, you would need to understand things like the service areas for the school, correct?
Correct.
So you would need a lot of details in order to be able to undertake those types of environmental analysis, right?
Yes.
Yeah, I don't have any further questions.
Thank you. And then I will offer Mr. Arambaru on redirect.
For purposes of doing environmental review, isn't it the case that you usually refer to the worst case scenario for a property?
I like to call it the allowed case scenarios, yes. Those that are allowed by zoning and those that have been previously permitted or are in existence, such as lighting of a stadium.
Okay. And that analysis would then take into account what the project objectives were that's identified by the proponent for the rezone. Would that be correct?
Correct.
And in your testimony, did you take account of all of those factors?
Yes.
And with regard to assessing, for example, trip generation, the testimony from Mr. Cooper tonight was that the anticipated size students, or the number of students at the high school was about 1,400, is that right?
Correct.
And does that permit environmental analysis of trip generation and other similar kinds of impacts?
Yes, it would.
Okay, thank you. No further questions.
Any questions from council members? Councilmember Winterstein.
Thank you, Mr. Wagner. I've heard tonight that we have a practice here in the city about, was originally called like phase 1, phase 2. I think we were suggested that we call it non-project action and project action review. And I heard tonight that a detailed analysis of this particular site wasn't done because, and we followed what we called non-project action kind of review. Do you have familiarity with that type of analysis? And you tell me about your experience with doing project, non-project, as it was explained?
Non-project, yes.
As it was explained how we do it here?
Well, every jurisdiction that has a comprehensive plan change or rezone change, those are required to, a SEPA checklist is filled out for those projects, and a determination is made. Either non-significance, mitigated non-significance, or perhaps even a determination of significance, depending upon the intensity or density. Those are the two main factors that you're looking at in a checklist, and the change that comprehensive plan and zone change would entail. So the elements of a project or the changes in intensity or density of the uses that would be allowed by the new zone. So that's pretty much the scope of the non-project portion of it. But if you have elements of a site that are known, such as the soils and such as water features around the site and other factors, you would also detail those in your SEPA checklist so the public is aware of what's available and what's involved in that particular site. Because SEPA is primarily a public notice document about the environmental elements of a project and what might be affected in a change, in this case, of zoning.
Okay, thank you.
I'm sorry, have you done a phased review in Washington State?
A phased review. I've done non-project and project reviews, yes.
So we, in our briefs today, we got a very specific definition of what a phased review was. Have you done a phased review in Washington State?
No, I have not.
Okay, thank you.
Not one that I can recall.
Thank you. Any other questions? Councilmember Goodman? No? All right. And I'm sorry to have to do this, but I simply have to do a 5-minute bio break. So we're gonna do a 5-minute bio break, and then we will get to the district's rebuttal witness. And we are back. And I want to ask Mr. Haney, are you going to have any rebuttal witnesses this evening?
No, I am not.
All right. With that, I will return to Ms. Skelton and her rebuttal witness.
Thank you. The district calls Wayne Carlson to the stand.
You swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Mr. Carlson, could you please state your full name for the record?
Wayne Carlson.
And where do you currently work?
I work for AHBL, 1200 6th Avenue in Seattle.
And what is your job?
I'm a principal planner at AHBL, managing a staff of 10 planners in 3 offices.
And can you briefly describe your educational background?
Sure. I have a master's in city and regional planning from Ohio State.
And are you certified as a land use planner?
I am. I've been certified since 1996.
And are you a fellow of the American Institute of Certified Planners?
I am, yes.
And is that a selective process?
It is, yeah. There's about, I think, 1,000 fellows since the inception of it, maybe 20 years or so ago, throughout the country.
What kind of work do you currently do as a land use planner for AHBL?
I do a mix of both current and long-range planning activities. We do amendments to comprehensive plans and zoning codes, SEPA environmental review, and then also we do school projects and things like that.
So you referenced SEPA. Presumably you're familiar with the provisions of SEPA.
I am.
And are you specifically familiar with the SEPA checklist?
I am.
Have you previously done a phased review?
I have.
Approximately how many times?
Probably 3 to 4 times.
And how many SEPA checklists have you completed?
In the 25 years I've been a planner in Washington State, I've done somewhere between 300 and 400. That's on average maybe 1 a month, maybe a little bit more.
Could we put Exhibit C8 on the screen? This is the SEPA checklist in this appeal. Have you reviewed this document?
I have.
Could you scroll down to section B, please? There you go. What is section B of the SEPA checklist?
Section B is a section where individual environmental elements associated with a proposal are described and analyzed. And they deal with earth, water, transportation, public services, aesthetics, those types of things.
When you've previously worked on SEPA reviews, have you done non-project specific reviews?
Yeah, those 300 to 400 environmental documents, and they include checklists, EISs, planned action EISs. I'd say somewhere between 5 and 10% of those have been non-project, so somewhere maybe 30 to 40 over my career, non-project.
Do you have a standard approach to Section B for non-project SEPA reviews?
Yes, for the cities, and I've been working with Bellevue, Sammamish, Bothell, Newcastle, and typically when we do a non-project SEPA environmental review, as allowed under WAC 197.11.235, we don't fill out Section B. Because Section B is a section that it's almost a blunt tool for a non-project environmental review. It asks a lot of questions that are really geared to project environmental review. And so what we do is Section A, we acknowledge that we won't be filling out Section B under, again, 197.11.235. And then we fill out the signature, which is Section C, and then D, which is the non-project.
So is it your opinion that it's incorrect to fill out Section B of the SEPA checklist?
No, it's not incorrect at all. It, you know, in some respects, it may add even some additional information, but it's not necessary.
And why is it that you do not fill out Section B?
Well, some of our clients find it's confusing to the public when you are asking questions that were clearly designed for project proposals, but for non-project requests, things like updating a comprehensive plan or an impact fee ordinance, for instance. You know, all of those require SEPA environmental review, and the questions, for the most part, for non-project just don't make a lot of sense.
Are you familiar with the single-family small lot zoning designation in the city of Issaquah?
I am.
And how about the community facilities designation?
I am.
What is your understanding of the purpose of the community facilities designation?
It's my understanding the community facilities designation is a zoning designation to implement the community facilities comp plan designation, which is used for publicly owned properties. And those facilities would be essentially any public facility with the exception of unprogrammed open space, which is community facilities-OS, and with the exception of community facilities parks that are programmed. So all of the others, whether they're transmission stations, schools, et cetera, kind of all fall within that kind of broad category.
Based on your understanding of the land use zones at issue here, the single-family small lot and the community facilities, is there anything that's necessarily inappropriate about siting a school next to a single-family residential zone?
No.
And why is that?
Schools are near residential uses all the time. They're considered to be typically good neighbors for residential areas. You want schools distributed throughout a school district, and so you want schools to be near where people live.
You've heard the testimony tonight about the school district's conceptual plans for the site at issue here, is that right?
Yes.
Based on your understanding of the status of those plans, would it be possible to conduct meaningful environmental review of those plans?
Not meaningful project environmental review.
And why is that?
Well, there's still too many things moving around. We heard from Mr. Cooper that the student count has been varying by nearly 15 to 20%, the number of classrooms by 25%. And so and we don't know where those elements that could generate impacts are necessarily even going to be on the site, especially with respect to things like light and glare.
How about with respect to traffic? What would you need to know to analyze traffic impacts?
Well, a couple things. We would need to know the size of the school and how many students, but that's only the very first step. That would establish trip generation. But a traffic study is so much more than trip generation. And as Mr. Cooper kind of pointed out, they don't even know exactly yet what the service boundaries are. So trip generation is really just a threshold, a figure, but then you have to figure out where are these trips actually going to go? Where are the students coming from? And so you have to take those trips and you split them and distribute them among the network and to the intersections. And so without knowing the service area map, you can't do a traffic impact analysis.
Thank you. Have any further questions at this time?
Thank you. Before we move on to the cross, any questions from council? Nope. I invite the appellant to cross-examine witness.
So when were you retained to provide your testimony tonight?
I think I learned of this very late last week.
So have you been out to the property?
I have.
Have you reviewed the plans?
I have reviewed the plans.
So you got involved late last week?
I was working this weekend. It wasn't fun.
Okay, I'll go, so was I, as a matter of fact. But you're not regularly working for the school district on this site, is that correct?
No, I'm not.
Can you do environmental review if, and fill out these Section B checklists or answers, if you knew where the site was and what was very likely to be proposed on it?
You could do the things for like earth and water, but things like aesthetics, no. Light, no. Noise, no, because those are contingent on where those elements are placed within the site. So about half of them you could, and maybe another half you couldn't. So you could not complete environmental review on this without having a pretty complete site plan.
Well, let's take question, you could move that over for me so we have a full view of the, so let's just take question 1B. Can you, for this property, can you figure out what the steepest slope on the site is?
Yeah, you could do, like I said, you could do earth.
Okay, that's easy to do. General description of the site, can you do that?
For the topography, yes.
Yeah. Can you figure out what the general types of soils are?
No, not in a meaningful way, because USDA soil surveys are not very accurate. So with respect to the infiltration capacity of soils and understanding the soils on the site and how they relate to the environment, and no, you couldn't do that without getting a geotechnical engineer out there, and you wouldn't start drilling holes for a geotechnical without a site plan.
But it talks about the general types of soils found in the site. Don't we have USGS and other maps that provide the general types of soils?
Here with the glacial till, they're wildly inaccurate.
Okay,
No.
But there are those sources of information available, are there not?
I don't think I trust them.
Oh, you don't trust them, okay. But have you ever answered a question about the general types of soils on the site by saying, well, the city of Issaquah has all sorts of soils? You ever given an answer like that? Like this one here?
Well, if I was doing an analysis of citywide soils, yeah, I would. If you're trying to say whether I would do it for a project, specific project site, then no. But this is for, it's my understanding this environmental checklist was for a whole suite of comprehensive plan and zoning code amendments, of which this was one of just several. And so I think that answer would be appropriate.
Did you talk about what's going on in the whole city?
Yeah, these disparate sites throughout the city.
So for your project, for your non-project review, does the non-project review focus on known plans for the property?
Not necessarily, no, because zones have a whole variety of available uses that are allowed. And so, no, we would, non-project, we would look at what are the differences in potential uses that are available in either the residential district that's currently there or the CFF.
Well, let's not kid ourselves. You know as well as I do that the school district needs this property to put up a high school that was permitted under the 2016 levy. We can agree on that, can't we?
Yeah, you can't build a high school without a rezone.
Without the rezone, okay. So the impact of the rezone is to allow a high school which would not otherwise be permitted. Can we agree on that?
Yeah.
And if we know the kind and type of high school, we know the number of students and the size, we can do some environmental review, can't we?
We don't know the number of classrooms. We don't know the number of students. I've heard some pretty broad ranges.
Well, that's fine, there's always broad ranges. Don't you ordinarily, when you're doing this kind of review, try to look at the most probable or worst-case scenario in these situations?
You look at probable environmental impacts, but not worst case. That's not the way the law reads.
Okay, but the probable use of this property is for a 1,400-student high school. That's what we heard tonight, right?
Well, I heard anywhere from 1,200 to 1,600.
Well, fine, so you're going to give up on environmental review because you don't know whether it's going to be 1,400 or 1,600? Is that the way you do your business?
No, I'm going to wait until I know through phased environmental review.
But that phase of environmental review on the high school is not going to take place without the rezone, is it?
Yeah, there will be a second phase, yeah.
I understand, but you've got to do the rezone first, don't you? You don't even get to this idea of having a site plan unless this rezone happens, correct?
No, I mean, you could get to a site plan without a rezone. I mean, I think there's even a provision within the city's codes that allow the review of these prior to rezone. But right now, there is no site plan.
Have you asked, as a part of your task, did you go to the school district and say, look, I'm going to give some testimony out here on Monday night. What's going on out there? Give me the best idea, the best iteration that you have right now of what you're going to do on this property. Did you do that?
I did.
You did? And what did they say?
They said, we're still working the site plans.
So you didn't ask for the best and most current plan for the property?
I asked, what is the proposal? And, I've seen a couple.
Okay. No further questions.
Any questions from council members before we move on? No? All right. Councilmember Ray.
And can you go down on this, I think it's section D. So, because we filled out section B. It's a ways. It's a little journey. More. I should have told you the page. I apologize. Almost there. Go back. No, that was right here. So this is the non-project supplement. And so I was curious about this, since this is a non-project event we're talking about. And these talk about things such as the discharge of water and measures to avoid such and reduce such increases are. And then there's one later about transportation. I'm just kind of curious if this is stuff that you would typically do during a non-project checklist.
Correct, yeah. Section D is specifically intended for non-project review.
And so what, it's getting late. I think we're all starting to feel like it's getting late. But
It's getting late.
This would be, since this is for the comprehensive plan and it's all these different rezones that are in the package, would this be in total, or would this, if you were doing it, would it break down into, would you look at specifics like parcel 17 in Talus and what impact it would have on these various things?
We do it in total, just as the city did it, because you want to, the comprehensive plan is a single document, so you want to understand the relationship by how all of these changes kind of affect one another. So you wouldn't do them individually, you would do them together.
Thanks.
Any other questions from council? Councilmember Goodman, you look like you're wanting me to stall for a few seconds till you can find the question that you want to ask.
It's just that the last question and answer perplexes me a little bit, because there is a difference, without getting too deep into the law, there is a difference between something that's considered a non-project and something where it's kind of not disputed that there's going to be a project on that property. And so I'm just a little perplexed with let's just bundle them all together and call the whole thing non-project. Was it, I mean, I don't think there's any, is there a dispute that there's going to be schools on this property? I mean, that's the only reason we're having the rezone proposal, right?
No, it's my understanding that there's a bunch of different amendments as part of this to the comprehensive plan. So, and it's my understanding that this SEPA kind of covers all those.
So yes, true. But for one of these, for two of the proposed rezones, one in Tallis is for school, and that wasn't appealed. But for the Providence Heights property, it was. And so my question is just, it's follow-up to Chris's question, which I had the similar thought in my mind about whether it's appropriate to bundle everything together and call it all non-project when at least one of these, Providence Heights, there is a specific reason for that requested rezone, and that is for schools. It's not a speculative, one day the district might be interested in the property. So how does that, so I'm interested in a little more elaboration from you on your answer. It's appropriate that we just bundle them all together and call it non-project.
Well, yeah, you're right. There is a that the school district requested this because of the desire to build a school or schools on this particular site. But I would argue that again, that as a the reason this is a non-project is that a couple things. First, it's a comprehensive plan amendment and zoning code update. Second, I don't think that there are any kind of comprehensive plan and or rezone requests that typically aren't precipitated by somebody who wants to do something. They may not have their plans on a website, but they still do have some type of motivations to reclassify their property. The only difference is that that there was a bond and a desire to go after money, but the site plan is not refined to the degree that you could do project environmental review, and so that would be my kind of distinction. I mean, I think there's a little bit more information that we know about the motivations to build, but I would guess that everybody that requests a reclassification is doing so because they have some future kind of development. And that's why these all kind of wrap into the comprehensive plan non-project environmental review.
What would your answer be if I asked you what you know about the Providence Heights property is if future development of schools on that site is probable? Is it probable or not?
Yeah, I would say it's probable.
Thanks.
Councilmember DiMichele.
Okay, so following up on that question, help me or clarify for me, isn't the non-project the same thing as the request for a zoning change? Aren't those two synonymous, or have I got that wrong?
You do have to do non-project environmental review for under GMA for rezones and comprehensive plan amendments.
I understand that, but aren't we talking about the same thing when we're talking about a non-project? If we're saying this is a non-project application, isn't the non-project the request for a zoning change?
Correct.
Okay, so that's my point. Thank you.
Councilmember Winterstein.
Thank you. Mr. Carlson, earlier in the beginning, you talked about Section B as being confusing to the public and clearly designed for project proposals. Now, we've heard tonight that in our docket of changes, there clearly was at least two, maybe more areas that the type of use was known that could go, like schools could be built there. Is there no provision in the way SEPA is done, especially for B, that you can say, okay, here's the non-project, and the little bit that we know about projects, here's section B for what we know about projects? Can you split apart section B, and what kind of practices have you seen there?
I haven't seen any of the clients, the cities, school districts, counties split those apart.
So when it's a non-project review, such as a comprehensive plan update, it's like the whole thing is non-project. There's not going to be project-specific anything in the SEPA?
Correct.
Okay, thank you.
Any other questions? Council Deputy President Batiste.
Thanks for your time this evening. So in the phased reviews that you have participated in, have they been, do you have any that have been similar in terms of a whole host of different changes and looking at those in a cumulative way? Have you worked on a phased review that has been similar to this?
Yeah, we've done environmental review documents for our comprehensive plans. And comprehensive plan amendments, of which some of the amendment requests were initiated by private applicants, where we knew that there was, maybe a motivation to change the use, and they subsequently came in with a changed use, but we didn't have a site plan.
And then you went forward with the phased review?
Correct.
Based on that?
Yep.
Mr. Haney, cross.
Yeah, I just wanted to clarify one thing that you said. I believe you referred to, was it WAC 197.11.235? Was that what you were referring to?
Yes.
I guess the reason I'm asking is I want to make sure that if the council goes and looks up that WAC, that we've got the right one. So, because the one when I look at 197.11.235, it relates to SEPA and GMA integration, and it doesn't seem to deal with the checklist. So I wanted to ask you if maybe what you were referring to was WAC 197.11.315, which relates to environmental checklists.
It was 315, it was, I believe 235 under section 3, I think also allows for, and I was describing that the reason, many of our clients, with respect to section B, don't fill that out is under paragraph 3, I believe, of that citation.
Okay, maybe I am seeing it now. So I just want to show this to you and just make sure that you, if I could, that you get the citation right for the city council and tell them which part of this you are referring to.
Right. It says an environmental checklist, if used, and a DNS is issued, only parts A, which serves as the fact sheet, C, responsible official signature, and D, non-project checklists need to be prepared.
So is your testimony then that under that section, which I believe is 3B of 235, that Part B does not have to be filled out?
Correct. That's the advice and that we've had from the city attorneys in Bellevue, Sammamish, Bothell, other places that we've done environmental review documents.
I have no further questions.
Thank you. Ms. Skelton, redirect.
Just a couple of questions. Mr. Rambaroo was asking you about specific subsections of section B of the checklist and whether you could fill them out. Do you recall those questions?
I do.
So my question for you is not whether you could fill them out, but whether it's necessary, in your opinion, to fill to answer those questions in the context of a non-project review.
Yeah, and my answer would be no.
Councilmember Goodman was asking you questions about whether the probable use of this property would be for schools. Do you recall that question?
Yes.
And you testified earlier about the single-family small lot zoning. Do you know whether that allows the construction of schools?
It does.
I don't have any further questions.
Any final questions for this witness from council? All right, you're excused. So in the order of proceedings in tonight's pre-hearing order, we say that now is the point where we could, if we chose, to allow closing arguments of 5 minutes each. And though the hour is late, I'm quite confident that 5 times 3 is still 15. So I would like to prevail upon my fellow council members to give us 15 last minutes so that we can finish with this hearing. I'm seeing universal support. All right. Did we have a order? Oh, we do. I'm sorry. It's in that very same document that I just referenced. The hour's late. We start with Ms. Skelton.
Oh, I'm first? It is late. This council may overturn the city's determination of non-significance only if appellants establish that the city's decision was clearly erroneous, and they have not met their burden tonight. In the context of a non-project specific review, the city did exactly what it should have done, and as you just heard from Mr. Carlson, they actually did more by completing Section B of the checklist, which is not necessary, and in fact, very well may have led to some of the confusion that the public and the council is experiencing with respect to how those questions should have been answered. I think Mr. Carlson's testimony was incredibly compelling on that point and certainly establishes that the city did what it needed to do with respect to the environmental checklist. But the bigger question here is whether the SEPA responsible official correctly made a determination that there were not significant adverse environmental impacts as a result of the comprehensive plan amendment, including the one specific component of that, which is to change the zoning and designation of the Providence Heights property from single-family small lot to community facilities. And I'd like to direct the council again to the last page of the packet that I handed out to you during the opening statement that shows you the uses that are allowed under the single-family small lot zoning and the uses that are allowed under the community facility zoning, and you will see right there why the official's determination was the correct one, and that there wasn't a significant intensification of the use as a result of that reclassification. Schools are allowed under both zones. Park and ride lots are allowed under both zones. Playfields and ballparks are allowed under both zones. And in fact, you heard Mr. Cooper's testimony tonight that the school district currently has middle schools and elementary schools with playfields that have bleachers, that have lights. There simply was not the type of intensification of use resulting from this comprehensive plan amendment that would necessitate further environmental analysis or an EIS, and the city's determination was absolutely correct in that determination.
Thank you. Mr. Haney.
Yes, it is late, so I will be brief. I've also submitted a couple of briefs on this matter, so you've got plenty of reading material to know what our position is. But I just do want to make a couple of points. First, this is a non-project action. In spite of all of Providence Point's protests to the contrary, there is no specific site plan that has been submitted for development. And when a site plan is submitted for development and the configurations and size of the buildings are known, and then that will be the time to do a detailed environmental review. Second, because it is a non-project action, as Mr. Carlson testified, but also as I pointed out in the brief, there are other sections of the WAC that say you can substitute basically the non-project supplement, Part D, which was filled out here, for those detailed questions in Part B. And the checklist was therefore adequate because we did fill out the provisions in Part D. Third, the change doesn't allow for a significant intensification in allowed uses. And I know there was a strong reaction from the crowd when I said that earlier and when I asked that question of Ms. Heinonen, but I heard no evidence presented by anybody here that testified that there was a significant intensification of use and significant differences between the impacts that a high school would have and the impacts that elementary schools, junior high schools, and middle schools would have, or differences that a stadium would have that would be different from the baseball fields, soccer fields, and football fields that are open for public use that the zoning already allows. So this is not a significant intensification of use. Fourth, because there is no site plan application, review of many of the impacts that Providence Point complains about is premature. Access points. You need to know where the access points are, and for that you need a site plan. Traffic. You need to know how big the buildings are, how many employees there will be, how many students there will be, and you need to know, as Mr. Carlson said, where those people are coming from, and therefore where the traffic is going to be distributed. Light and glare, you need to know where the light's going to be. You need to know where the stadium's going to be. You need to know where the lighting is going to be in relation to other, in relation to the buildings on the site, and also in relation to where it's going to be to the surroundings. Lights that are on 228th may be entirely different than lights that are directly next to the Providence Point residents. And so you need to know where those are going to be. And stormwater runoff, you're going to have a stormwater code that requires a detailed stormwater plan and how you're going to discharge drainage, and you need to know what that plan is and how those codes are going to affect it before you can determine whether there are any environmental impacts. So given that there is no site plan application here and that it is constantly changing, given that, Director Niven correctly used phased review. And I know Mr. Wegner testified about, no, we should have done more, but Mr. Wegner's never done a phased review before. He testified to that, and I'm not sure, we didn't ask him really about his experience with phased review, but he's never done one. So other people here have done them. Mr. Niven has done them. The city routinely does them, and that's where you decide what things you can look at now based on what you're looking at. And then, when you get a detailed project design, you look at additional things. And those things will certainly be done at the time of project level SEPA. So environmental review will take place in phases. That is what SEPA allows you to do. It's what I laid out in my brief about phased review. And when the master site plan comes before you, there will be additional SEPA done, and you'll have a chance to review these detailed environmental provisions then. So with that, I would just ask you to uphold Director Niven's decision on the DNS and move to actually addressing the merits of the application when it comes forward, of the comprehensive plan amendments when they come forward. Thank you.
Mr. Arambaru, you get the last word.
Well, you can run, but you can't hide. And you can't hide from the fact that the Issaquah School District is moving on this comprehensive plan and rezone to build a new high school. That you can't avoid that. I mean, we can all talk about this and that and the other thing, but everybody's running from this. The district says, oh, not really sure what we're going to do. We might do this or we might do that, and there might be a feint this way and a feint that way, and who knows what's going to happen. And Mr. Niven amazingly keeps his blinders on. He doesn't talk to anybody, doesn't even talk to his own staff after they've had meetings with the district to talk about these things. He doesn't talk to the district about what's going on with this application. What's going on with this? Again, we talk about phase review. This isn't phase review. Unless this rezone happens, there ain't going to be a site plan review for a high school. It's not going to happen. That's the reason we're here. And that's the reason that we're so concerned about a checklist that essentially is gibberish. How many people are going to be on the site? Well, there's 37,000 people in Issaquah. Well, that's a great answer. That's helpful to everyone. And everybody's concerned, as Mr. Carlson was, about misleading information. We'll talk about misleading information that's distributed to the public on this material. 1,400 student high school, 3 stories high, 215,000, 230,000, fine, it doesn't make an awful lot of difference. That's what's going to happen. 600 student elementary school, 3 stories high, 73,000 square feet, single access to the property off of 228th, not 2 accesses. That's what they've said in all this material. That's what needs to be reviewed. That's what the public here needs to be confident that the city is really looking at the issues that are really before them, and not put up with this idea that it's all smoke and mirrors. We can study these things. We can take a look at the impacts on the community. We can take a look at the traffic. We can take a look at the stormwater. We can do all of these things, and we can answer questions in the checklist in an honest and accurate fashion. And we talk about stadiums and other things. We can go out here tonight and drive up the hill, and on Friday Night Lights, remember the TV show and the movie? That's what happens. That's what happens in this community and other communities on Friday nights. It's loud, it's noisy, there's lights that are impacting other people. Let's come to grips with those issues. They are issues in the community. So putting off review simply means that the public isn't really going to get a chance to look at what's going to happen as we go along. Phase review just doesn't work here. We've got to be honest with the people in the city about what's going to happen, and we're not, and your staff has not done that job. So, and staff, by the way, hasn't produced even a staff report for you guys. Not a staff report. Here we are, months into this process, and the only piece of paper that you've gotten from your staff is a DNS based upon a checklist that is mostly gibberish. Let's get the full disclosure of these impacts. And it may be that as we look at that full disclosure and make them do the full disclosure, we end up with some information that allows us, this council, and staff to do a mitigated DNS. Maybe there's some things we can do out here to this site that makes it more palatable to the community, more accessible to the community. As I said, this has been disrespectful to the people in Providence Point, and I think the people in the community. Kicking the can down the road simply doesn't work. So here's what I'm going to ask the council to do. Number one, grant our appeal. We're right. The city has not done this correctly. Number two, direct the staff to go back and do a checklist based upon what the proposition is before us, which is the building of a high school and an elementary school and a stadium. And three, redo the DNS. Maybe we get a DNS again, I don't know. But maybe we get an MDNS, and what we think is appropriate, a DS, and doing an impact statement on this. So I'm right there at 000, and I'm done. So thank you very much. I'm available for any questions you may have.
Thank you. At this point, unless there's any objection from my fellow council members, I would move to close the record on appeal number 19-00006. And I guess that doesn't require action, but this does. I would like to move to postpone deliberations to a future meeting date to be set. I don't think we necessarily want to try to do date certain this evening.
Second.
Discussion? Councilmember DiMichele.
So I just want to be clear that we continue to be in a quasi-judicial role. We can't talk to anyone about this topic outside of deliberations. I just want to make sure that that's understood. Is that correct?
That is correct.
Okay, thank you.
Councilmember Walsh.
I would also ask that if we are having future deliberations, that it be in a public context that would allow public attendance. Is that our intention?
Is there anyone who would argue otherwise?
Is that even an option?
Councilmember, it is an option.
It is an option because it's a judicial process. And even, I feel, speaking just for myself, that if we were to go closed door and have a deliberation, that coming back out in the public, I mean, would be expected for full transparency on any one of ours, how we came to whatever conclusion we've come to.
That would be a vote in support of open.
Yeah, I think, we're a legislative body that doesn't have experience doing things behind closed door except the executive session. And this being a judicial matter, by the way, you're a pretty good judge for your first time. I mean,
thank you.
There's areas for opportunities for improvement, but that was pretty good.
Of course.
But so it's all kind of new to us. And I just think because that's an option, and I know the desire, and I share that desire to be transparent. I've said that many times before. I don't think we should just take that off the table at this point.
I think I was just clarifying for the public that the general intent of the body right now is not to stop public deliberation and take it to closed doors, but merely it's midnight, we're tired, we're not going to get a good conversation out of this, and so we're looking for another date.
Understood. Any further discussion? Councilmember Goodman? No. Nope. All in favor?
Aye.
Aye.
Opposed?
We need a motion?
Oh,
to close it, sorry. Yes. Sorry, thanks.
I believe that was unanimous.
Aye.
Yes. All right, and before I hand things back off to the mayor, I just really want to thank Ms. Liao for all of her assistance this evening with all of us six non-legal types and one legal type.
Well,
Thank you, Council President Martz. We're still in session, and the next item is good of the order, and I'm thinking there isn't any good of the order, but I am asking if anybody has anything to share. Upcoming council meetings, I don't have a list in front of me. We do have the, Tisha, do we have any dates that we can share tonight? Monday the 9th? Monday, December 9th?
7:30 a.m. at Tibbetts Creek Manor.
Thank you, City Administrator.
The 10th of December is a council study session.
Yeah, here it is.
Currently scheduled for 6:30. If the council's looking for an optional meeting date, that may be one you want to look at. And then your last meeting of the year is scheduled for December 16th, 7 o'clock, regular meeting.
Thank you. It was up here. I missed it. There is no executive session this evening, and there being no further business, the meeting is adjourned at 12:13.
Tuesday.
Tuesday. On Tuesday.